just ignore the clock. It's not quite right. I'm Kate Qualley. I'm the Planning and Environmental Services Director for Winona County. So on behalf of Winona County and Houston County, welcome everyone. We're going to have a presentation on making solid land use decisions. As volunteers, your valuable time helps counties' residents make critical land use decisions. And this kind of training helps us all make these decisions, which can be tough and sometimes controversial too. I will say that in the interest of time, we're being recorded for those folks that weren't able to attend tonight, and we'll get the presentation out to you. I wanted to quick read through, to save time, little information about Jay, our speaker. He's a founding shareholder for the law firm Rupp, Anderson, Squires, and Walsberger. He received his Juris Doctor degree from William Mitchell College of Law, and his primary areas of practice and experience include general municipal law, real estate, land use, and zoning, as well as municipal litigation and more, including appellate work. He's argued over 50 cases to Minnesota's appellate courts and is licensed to practice in both Minnesota and Wisconsin. I personally heard Jay speak a couple of times in the last 6 months, and I was very impressed by his fast-moving training presentations. So please welcome Jay Squires.
I'm going to use the handheld so I can walk around a bit. Can you hear me okay, or can you hear me okay? All right. Great. Let's start out by identifying. I figured out the first row here with the bride side and the groom side with Houston and Winona. How many county board members are here? Couple? Winona? No, county board? Okay. County board? Okay. How about planning commission members? Board of adjustment members? Staff? Anyone else? Okay. And where are you from?
Houston County.
Okay.
He's from Caledonia. I'm a resident of the city of La Crescent, but been on the comprehensive plan with the Board of Planning Commission there.
Okay. Great. I like to, for those of you who have been at presentations that I've been involved in, where my partner Scott Anderson or both of us, you know that we like to engage in more of a dialogue, and that first question is always the hardest for someone, so you'll get extra points if you're the first question asker. But from my experience, once we start engaging in a dialogue and that person asks the first question, to a certain extent the floodgates open up and that dialogue can begin. And I found from my experience too that we get the most value if I'm not just a talking head up here for 4 hours, which is a long time to be a talking head, but when we can engage in conversation about issues that are most important to you. I have a sense of what some of those are from having worked with both your counties over the years, but perhaps not all of them. So you may have issues that you're dealing with now that I haven't been involved in or I'm not aware of. And if I touch on a topic that strikes a familiar chord, please feel free to raise the question or say, we ran into that in our county in this circumstance. What do you think about that? Sometimes when it's a very large group, maybe all counties from the state represented at the AMC conference, I'm a little bit hesitant to engage in question answers that are unique to one county because that can be frustrating for the other 86. And it's not relevant. But if it's only two, I think we can feel a little bit more free to be able to have those conversations. So please do that and don't feel badly saying, what do you think about this we ran into last week? I think we'll start out, we've got 4 hours, but we're going to take a little break, I okayed with Kay, about after 2 hours or so to allow you to stretch your legs and tend to business. If you want to eat during the first 2 hours, feel free to do that. If you want to wait till we have 15 minutes where we can sit and converse, you can do that too. First come, first serve, so if you want to get what you want, there are different things, go up and grab that. But we'll take a break about 6:15 or 6 o'clock or so. But if you need to get up and go out, don't feel badly about that either. So with that, let's get right into it. I've got about a 37-page outline. Usually we don't cover everything in that outline in an 8-hour presentation, let alone a 4-hour presentation. So some of the things I'm going to skip and leave to your reading, but I hope to touch on most of them, at least in a general fashion. I always like to start out talking a little bit about the philosophy of land use regulations to set the table as we talk about some of the more common permits. So I want to talk first about about the breadth of the county's authority in the area of land use regulations, just so that we all understand, because especially those of you who have been appointed to a board or a commission, you may not necessarily get the discussion at this level. But counties in Minnesota are statutory creatures, like cities and like townships and like school districts. For those of you who are old enough to remember, I think probably it goes back maybe 15 years ago, there was a legislator, I think in this general area of the state, if I recall from Rochester, who introduced a bill to abolish all townships in the state. He got mad at townships, so he introduced a bill to say, let's get rid of all the townships. But that could be true of counties too. So counties only exist because the legislature has created you. So just as easily the legislature could do away with counties or make fewer counties. You hear discussions every now and then about changing, combining counties, making larger counties more in the north part of the state. But the legislature could do that. So you are a creature of the wills of the legislature, and every power that a county exercises has to come from the legislature. So everything we can do has to be pursuant to a statutory grant of authority where the legislature has said, counties, you have the authority to do this. And in the area of land use, that is true as well. So whenever I get a land use case or I'm consulted by a county with a question about can we do this or can we do that, the answer always begins with a search for what is our statutory authority to be able to do that. And in the case of counties, the County Planning and Zoning Act is Chapter 394 of statutes. And I think Kay said they're sitting at the end of the table. Not that we're going to engage in digging through the statutes today, but if you like to look at statutes, Chapter 394 is the chapter in statutes that is the general authority for counties to regulate the use of land. There are, of course, other statutes that come into play and other administrative regulations that control our exercise of that power. For example, the rules on shoreland come out of the DNR, so there are administrative regulations we have to look at as well. But our general authority to regulate the use of land is in Chapter 394. Now here's where I'll get a little bit philosophical, just to kind of perhaps get you thinking about how we approach zoning. If you're a student of philosophy, if you know who Immanuel Kant is, and you've heard of the concept of utilitarianism, anybody study that? The needs of the greater good is always served. This kind of worked into our democratic thinking as well, but the needs of the many outweigh the needs of the few. So whatever particular act would protect or serve the greater good of the greatest number of people is the act that we should pursue. And in a way, land use regulation is based on that philosophy. Because when we make decisions about what's best for the community as a whole as opposed to what's best for the particular person, which is usually the applicant, isn't it? Or to take it from a different perspective, how many Star Trek fans? Well, the utilitarian people are the Star Trek fans too. Star Trek, you remember Spock was a Vulcan? And do you remember the common phrase that Spock would say, especially if you saw the movie where Spock died in the radioactive chamber? You recall when he was starting to melt and his face was starting to melt, and he told Captain Kirk, he said something along the lines that remember, Jim, the needs of the many outweigh the needs of the few. I will always be your friend. And then he died. So Vulcan, if you're a Star Trek fan, that book and those shows were actually based on particular groups in history, but the Vulcans, I think, were the Greeks, as I recall. But that whole concept as well of the needs of the many outweigh the needs of the few is exactly how we approach zoning decisions. So with that philosophy, let's talk into how the nuts and bolts actually work. Again, Chapter 394 is the chapter that we're interested in. Cities and towns are governed by a different set of statutes in Chapter 462. So as you engage in zoning for counties, we always want to be sure that we are looking at Chapter 394 and not at Chapter 462. Oftentimes, even attorneys I see from time to time cite provisions in Chapter 462 as the ones that are governing particular decisions we have to make or activities, and that doesn't apply to counties. It's Chapter 394 as well. So how is Chapter 394 structured? Generally, Chapter 394 authorizes us to adopt and enforce things that the legislature calls official controls. That's an important term because those are the tools that counties can use to regulate the use of land. And what are some of the most common official controls? The first one is a zoning ordinance, and that's probably far and away the most common thing that you deal with on a day-to-day basis as either planning commission members, Board of Adjustment members, or county board members as well. So you're using the zoning ordinance to regulate the use of land. How does a zoning ordinance work? Just a little bit of historical background too. Back in, I think, 1923, there was a community in the state of Ohio that was faced with, the board members were faced with continual complaints from residents that their neighbors were engaging in activities that were noxious and causing problems for them. And the citizenry demanded that something be done about it. So this crazy group of local aldermen got together and they created this document and this process where they took a map of the community and they carved it up into grids and they decided what they would allow could be done in a certain portion of the grid, and they literally carved it up and said, in this area you can do this, in this area you can do this, and in this area you can do this. And then on top of that, they said, if you can do that by our judgment, then we'll make up some rules about how you can engage in that particular activity. And that was the village of Euclid, and that's come to be known as Euclidean zoning. And when our legislature adopted the Planning Act in 1958, the legislature adopted that specific concept, and really that's the concept that's used across the country, Euclidean zoning. So the ordinances that you use and that are used throughout the state of Minnesota are Euclidean zoning. So by that I mean in applying the zoning ordinance, we have a land use map that has been adopted by the county board that designates the zoning district of each given property within the county: agriculture, residential, business, commercial, industrial, etc. And then within each zoning district, the county board has said, for you have allowable uses, you have permitted uses. And the concept of a permitted use is one that the board has determined as a matter of policy that use is consistent with that zone and it doesn't need to be exposed to a higher level of scrutiny. So farming in an agricultural district, a single-family home in a residential district, those things are so consistent with the vision for that zone that all someone has to do is come to the zoning office, to the counter, and apply for a permit to be able to do those things. And they're off and running to build a house in a residential district. That never gets raised up to the level of the planning commission or the county board, or if variances are required, which we'll talk about later, the Board of Adjustment. Then on top of permitted uses, there are conditional uses. We'll talk a little bit more about those as well, but conditional uses is that list where, the way that I like to think of it, if there's an evil person that might implement that use and cause problems, we want to be sure that we have the ability to exercise greater control over that. So that list of conditional uses, as you're aware, then is a use that has to come up and be exposed to more public scrutiny. So under law and your ordinance, someone that wants to do one of those things then has to make an application, but they have to navigate their way through a public process where there's a hearing and there's notice and there's an opportunity for people to say, here are the concerns that I have, so that as decision makers you can address those concerns. And then the second important thing is you then have the right to attach conditions. Someone comes in and says, I'm never going to be able to sleep at night when they're operating that saw at midnight. Well, then we impose a time limitation on that. You can't operate your saw after 8 o'clock. So that's a mechanism that we can use. So the zoning ordinance is establish the districts, identify the allowable uses, determine what's permitted, determine what's conditional. And then the final piece of that are the performance standards. So you can do that use, you can engage in that allowable use, permitted or conditional, going through the process, but here are some of the limitations that will apply to anyone that wants to do that. Setback requirements are the most common performance standard, height limitations, things like that, usually quantitative in nature. So residential house, residential district can come in and apply for a building permit, but you have to be set back 10 feet from the side yard property line. That's the performance standard, and all the other ones as well. So a set of rules that says, yes, you can do that, but here are the 10 or 15 things that will limit your ability to install that particular use. So that's the most common tool in administering land use regulations in a county that we've been authorized under Chapter 394 to undertake. Subdivision regulations is probably the second most common tool. And simply what a subdivision is when you divide a larger piece of property up into 2 or more smaller pieces. That's subdividing property. That act under Chapter 394 can trigger our ability to be able to regulate and control that process. So someone wants to do that, boom, our subdivision ordinance applies, and we can impose the requirements of our subdivision ordinance, which can contain various requirements of platting or in a recent authority given to us, dedication requirements, park dedication requirements, or cash in lieu of. That's something that was always in Chapter 462, but got plunked into Chapter 394 recently. So another thing, it triggers our ability to be able to require a development agreement. And this is a tool that counties don't often use. Do Winona and or Houston use development agreements when you subdivide? Okay, all right. So you're focused on one particular use. A development agreement is much more commonly used in cities, but it is a great tool to be able to control all kinds of things that relate to the development. It contains plan review, plan submittal, security requirements, park dedication requirements, what happens at a default, all kinds of things that give the county great leverage and control over what that particular person wishes, or landowner wishes to do. Of course, the most common thing is, and they're more necessary in that context, but like in a larger city where someone wants to build a 100-lot subdivision, there's a lot going on in terms of infrastructure that's installed and things like that, so it's more necessary, but you should consider whenever you have a subdivision the notion of having a development agreement as well. So then on top of that, just in terms of if you picture the quiver that you've been given by Chapter 394, the arrows that you have in it to regulate the use of land, you've got the zoning ordinance, you've got a subdivision ordinance as your principal tools. Then there are other official controls that can apply to a use in any given case, like shoreland regulations. So if it's shoreland property, then you have a shoreland ordinance that's mandated by state law. Floodplain property, you have a floodplain ordinance that's mandated by state law. If it's a feedlot, I'm guessing you probably have separate feedlot ordinances, or at least provisions that deal with feedlots that then apply as well. So in any given case, I had a case recently that involved an expansion of a feedlot that was located in shoreland area where there was floodplain on the site, and the county had a separate feedlot ordinance. So we had the zoning ordinance, shoreline ordinance, floodplain ordinance, feedlot ordinances, all having some impact on the proposal. So every particular official control that a county has dealing with a specific topic may apply like a sandwich layered on top of each other to a given proposed use. So in concept, that's how it works. You have two main tools, but also the ancillary tools that are arrows in your quiver that can apply in any given case. The last thing I just on the top of page 4, just to mention as well, that is a tool that I think is coming into more common use. Usually it's plunked into the zoning ordinance, but it's the authority to designate interim uses. It is another one of those examples like park dedication requirements where there are all these little nuanced differences between Chapter 394 and Chapter 462. Cities have always historically had the ability to designate interim uses. I'll talk a little bit more about that later. I just want to distinguish that from an interim ordinance or a moratorium. So sometimes you hear the phrases moratorium, which is also called in statute an interim ordinance. That's different from interim uses. So interim uses is the authority to be able to specifically impose time limits on a permit for a particular activity. I've gotten over the last 29 years, I've always gotten the question from time to time, well, can we impose time limits on conditional use permits? And my answer was always, well, I don't know for sure. We can try, but interim use permits are specific authority to be able to impose time limits. So if your counties don't have and use the full breadth of the authority to be able to identify interim uses in your ordinance so that you can impose time limits on those, that's something that is an addition to our quiver of authority that we want to be able to use. So think about that as well. So that's the breadth of our authority to be able to regulate the use of land. And I want to talk next about limitations on that authority because we tend to, I've seen over the years, we can have a tendency as humans to get cavalier about our exercise of the authority. And we think, well, since we have the authority, we can do anything we want. We're like Caesar. We can say, you get the permit, you don't get the permit. I like you, I don't like you. And that's not necessarily the case. We have to be aware of all the limitations that exist on our exercise of that authority, where if a party, whether it be the landowner in the context of a denial of a permit, or others in the context of the grant of a permit, there are limitations that exist by way of things I'll talk about in a moment that you have to be cognizant of because these are the areas where we can get into trouble, where if we don't honor that particular limitation, that gives the other side the authority to be able to say our decision was arbitrary for this reason. So be aware of that. Actually, I have to say, in probably the last 10 years, I have handled more cases challenging the grant of a permit than I have seen cases challenging the denial. It used to be the opposite before then for some reason, but now it seems that the citizenry that disagrees with your decision to allow something is at least as active, if not more active, than a property owner who didn't get what they want. So we have to be careful in both contexts as well. So let's talk a little bit about the limitations on the use of land, and I want to start with concepts arising from the Constitution. And there's a federal Constitution, the one that starts out, "We the people," that we've all heard of. And then there's a state constitution as well. Sometimes people don't realize that. And actually, our state constitution in the area of land use can be a little bit nuanced and different than the federal constitution. One example is the takings clause in the federal constitution says property may not be taken without the payment of just compensation. That arises from Old England when the king would just take whatever property he wanted. And then the Magna Carta did away with that and said, no, we think the king can take it, but he has to pay us for it. So then we got that in our federal constitution, but the Minnesota Constitution says property shall not be taken or damaged without the payment of just compensation. So little nuanced differences like that can play a role in land use regulations. But the constitutions have, both federal and state, have common provisions that can have significant application in the land use context. And the first one I want to talk about is the Equal Protection Clause. You've probably heard about that, I hope, equal protection. And the Equal Protection Clause dictates or requires that similarly situated people be treated the same. So have you ever had anyone in a land use context come up and say, or make the argument, I should get this permit because you gave the same type of permit to Joe Johnson across the way 4 years ago? Oftentimes in northern Minnesota, where it's always about lakes, you gave a variance to put a boathouse to Joe Johnson across the lake 5 years ago. Ever heard that argument where someone's citing a similar decision that you made? They don't verbalize it that way, but that's kind of a concept of equal protection. So how does equal protection shake out when it comes to land use decisions? We do generally have an obligation. It's been said that consistency is the hobgoblin of small minds. We do generally have an obligation to consider consistency when we apply our land use regulations. But let's talk a little bit about how that works in the land use context. Again, the rule is we have an obligation to treat similarly situated people the same. That's a good rule. But what does that mean? Similarly situated is the key. What the courts say is in the land use context, similarly situated means similar both with respect to time and with respect to circumstances. So when you think about time, my example of you gave that permit to someone 5 years ago for the same thing, the courts have found and said that you're not similarly situated with respect to time unless you're at the same meeting or very, very close in time, maybe less than a month. There's a case that says the passage of a month makes people not similarly situated with respect to time. And I think the concept of that is logical because in the example of, well, you gave this permit, same permit 5 years ago, well, that may have been a different board, and what if that board was wrong? What if they made a terrible decision? Does that mean that we're stuck to propagate a terrible decision forever? That doesn't make any sense. So the courts have narrowly construed that and said, with respect to time, it's got to be very close. And the one case I'm aware of that a court found a violation of equal protection in the land use area arose in the city of Arden Hills. People know where that is in the Twin Cities, up where the old munitions factory was, if you've ever followed the stories about what goes on there. Two colleges are located in Arden Hills, Northwestern Bible College and Bethel, very close to each other, both with very similar missions. And ironically, they came into the city and they applied to the city to each construct a fine arts center, which was a conditional use under that city's zoning ordinance. and their applications were processed, and they came up at the same meeting. So the city has them on the agenda, and to make a long story short, city denies one and grants the other. The one that didn't get it, and I forget which one it was, sued and argued equal protection. Court said with respect to time, they are similarly situated with respect to time. It's at the same meeting. Now, that decision was overturned, and I would say the reason it was because the council members probably distinguished between the two in their minds, but they didn't do a good enough job distinguishing on the record as to why the two were different. But with respect to time, that's the one case that I can say that the court has found similar situatedness with respect to that, to time. So, moral of the story is, you can say this in a nice way, but when anyone comes in and makes the argument that you are bound to make the same decision based on something that happened 5 years ago, or 2 years ago, or 1 year ago, or 2 months ago, the answer is that doesn't bind this board. And I think you can say it nicely, come up with a nice line, but thank you very much for the information. That doesn't bind this board. We make every decision on a case-by-case basis, so tell us what your case is. And then you can get away from that. Second part of the equal protection, similar situatedness requirement is similarly situated with respect to circumstances. So what the analogy I like to do, or pose, the question I like to pose is it a spider doing a push-up in the mirror? Is it exactly the same with respect to every circumstance? Is the lot the same size? Is the topography the same size? Is there different vegetation that will affect the view or the screening on one lot versus the other? And when you really think about it, real estate is unique. There's only one piece of property like a piece of property, and that's itself. Every piece of property is different. So when you are faced with that extremely rare circumstance where you are at the same meeting and you have two identical applications, and you say, oh my gosh, we talked about this at that training seminar, what do we do now? Then you ask the question, are these applications similarly situated in all respects? Or are they different? How are they different? Going back to Arden Hill's exercise, they must have felt that they were different. We don't know why, and they made an error in not being able to elaborate on that, but are there facts that are different? Is the property different here versus there that would cause you to make a different decision on that particular permit? So that's the concept of equal protection as it applies in the land use area. Any questions about that? Still waiting for that first question. Let's go on to the second concept that comes out of the Constitution, and that's the taking clause that I mentioned a little bit earlier. The provisions in both constitutions that say you can't take property without the payment of just compensation. That applies not only to physical acquisitions. So the county highway department needs to widen County Road 19, and they need to go out and they need to acquire additional right-of-way to widen that road. They're physically acquiring that property. If they can't work out a deal with the property owner or property owners, we have the right to exercise eminent domain and physically acquire or take property against the property owner's will for that public purpose. So that's a taking. But in the 20s, the U.S. Supreme Court said in a Pennsylvania case that land use regulations can constitute a taking as well. And they can constitute a taking if we deny all economically viable use of property by the application of our zoning regulations. It's a difficult standard to meet. It's an argument we faced in the recent sand ordinance and the challenge. It was the primary argument of the property owners. I'm not going to talk too much about the case because we have the district court decision and the appeal period still pending, but one of the arguments that's a public record by the property owner, Minnesota Sands, was you've taken our property because we can no longer extract sand for the purpose for which we intended. And the court rejected that argument, finding that under the county ordinance, they were allowed to engage in mining, albeit at a less intensive level than they wished, but they still could engage in mining, and therefore they had not been denied all economically viable use of property. So that's one example close to home where a taking argument was made in a land use context and how the court analyzed it as well. The admonition I would say with respect to taking, and this is a concept that there probably isn't a whole lot of case law on, but I think practically as land use regulators, I would say let's consider not using a sledgehammer to kill a fly. So if we see a fly there and we can kill the fly with a fly swatter, let's use a fly swatter and not use a sledgehammer, because that will be as effective. And I think really in the eyes of the law, that's a good approach. When we look at things and we look at particular alternatives, we look at the one that's most designed to be most effective to regulate that particular use rather than going overboard and doing something that's unnecessary as well. The third constitutional provision that applies, again, both in the state and federal constitutions, is the Due Process Clause. Have you heard due process? Someone argues due process. There are two different types of due process in the constitutions. One is substantive and one is procedural. And the substantive provision requires, in a sense, that our decisions be within some parameter of reasonableness, that we aren't way out in left field when we make a particular decision. It's kind of a safety valve to allow the courts to intervene where we've made such an aberrant, strange decision that the courts can say you violated substantive due process. And I'm not aware of any case where a court has said that has been the case. Again, in our Sand case, they challenged Winona County's ordinance on substantive due process grounds, which I think were fairly quickly dispatched of with a district court judge. But the one case where a federal court discusses it provides some guidance that I cite in the materials that says if a decision is made by the flip of a coin, that's a substantive due process violation. So if you're just deadlocked on the board, 2-2, let's say you have 4 there, and you say, well, we don't know what to do, let's flip a coin. Heads, they get the permit. Tails, they don't get the permit. That could be a problem for us. Or we like him, let's give him the permit. He's a pain in the butt, let's not give him the permit. If that's the record that we have, then that would be a concern as well. So something just generally to be aware of, that there are parameters that prevent us from being truly outrageous. But I have to say, in my years of practice, I haven't seen it yet. I've seen some cases where it mystified me that a decision was made on the basis it was perhaps, but I haven't yet seen the case where I say, I think we have a federal substantive due process violation here. So just be aware of that. The more common concern in the due process area is procedural due process. So there's the obligation to not act outrageously, but there's also an obligation to be fair. So in that concept of fairness, procedural due process, generally what the courts have said is that means notice and an opportunity to be heard. At a board level, you don't get concerned about notice because it's not your responsibility to give notice. In your ordinance and in state statutes, there are requirements for notice. You send out letters to people around a CUP applicant, you publish things, you post things, etc. So those prescribe the notice, and if those things are met, it would be difficult for someone to argue lack of notice. It's usually the opportunity to be heard part of it that people take issue with. So what does that mean, opportunity to be heard? Does it mean that they have a right to have their view endorsed by the board? No. Does it mean that they have a right to disrupt your meetings and make life a living hell? Does it mean that they have a right to keep you here until 2 in the morning, listening to them? No, it just means literally a right to be able to speak their piece. Here's how I feel about the application. Do we have the right, balancing that, do we have the right to maintain order and decorum and to get home before midnight and to not have to listen to the same thing 25 times and to not have people read letters from the podium that are 10 pages long that you have in your packet and you've read already? All those things, we have the right to be able to have an efficient process as well. So they have a right to be able to say, here's how I feel about it. If we deprive someone of that fundamental right, no, we're not going to let you speak. Or we will allow all the opponents of this use to speak, but if you support it, we're not going to allow you to speak. That's a procedural due process issue, as well as probably some other issues as well. So notice and an opportunity to be heard. Here's a new slant that has been developing in the courts that has been crammed under the concept of procedural due process to be wary of. And there have been a number of cases in the past 5 to 10 years that I think are still out there potentially to be made. And that's the concept of prejudgment. And the argument is, if you as a decision maker have made up your mind on a request before you even hear the applicant give their pitch as to why they think they meet the standards or are entitled to it, you have violated due process because you really have effectively taken away their right to be heard, which is rendered meaningless if you've already made up your mind, if you follow my logic. So that arose out of a case, and just to give you some sense of the background, that arose out of a case involving Minneapolis. Anybody familiar with Minneapolis politics? They're just crazy how things work up there. But they have all the council members, and they have wards, and they have all these neighborhood commissions that are connected to the council members, and it's a very interesting process. In one council member's ward, there was an active neighborhood association that was opposed to a project. And they, as citizens do, reached out to their council member to attempt to influence her to vote the particular way, to not approve the project. And this council member didn't just listen, thank you very much for the information, that's important, I'll be sure that it's circulated so everybody's aware of it. This council member engaged in very much of a dialogue, sending emails such as, I share your concerns, I will do everything I can to make sure that this project is defeated, And when ultimately the application was denied and a lawsuit was initiated, all that communication is discoverable. So depositions were taken. The other side got a hold of all of that discourse and sued, alleging, among all kinds of other things, violation of procedural due process. The mind was made up before we even had our application heard by the council. That went up and down the court ladder a number of times, ultimately was resolved favorably on different grounds, but it set the stage for the concerns that we have that have been raised in other cases. Never really got to the point of hurting a municipality badly yet, but I think that the concept and the precedent is there that we have to be very careful of prejudgment. So especially as elected board members, for those of you who are here, maybe it happens less with respect to Planning Commission members, but maybe more with respect to Board of Adjustment members as final decision makers. How many times have you been cornered in your community by someone, whether it be the applicant or someone at church or in the local restaurant or by email or in a phone conversation, where they want to know whether you're going to vote for or against a particular request? And how many times have you either stated or implied what your position is on that particular matter? I'm not asking you to answer it. We're being taped. But I just posed the question to you because it's a practical reality. In a community where many of you know each other, you go to the same churches, you go to the same restaurants, you engage in conversations, issues that are important in the community, hot button topics, land use proposals that are contentious are discussed. And people want to know how you feel because you're important in a decision. So that's going to happen, and you have to be aware of that. And what I can give you is a good way to respond to that. At least I think it's a good way. You can pattern this as you wish. And that is to tell all those people to validate their concerns. That's a very good point. I understand your concern. I completely understand your concern. But then say, it's important, we have a process for you to share that concern with every decision maker. So it's not just me, but it's everybody that you make aware of that concern, because that's good information that we have to know as a body. So here's the public hearing. Come to the public hearing and share that information. Or if it's written information that they give you, that's good, important information. I can't talk about that in this context, but I will share it with the full board, and the board will consider it. That's what I can promise you, that I will pass that on so it goes through the proper channels. And usually from my experience, and I was on a planning commission for 10 years myself, usually people are satisfied with that, especially if you start out by validating that, that's a great point, I really understand that, but here's our process to be sure that that information gets before it. Usually people won't continue to make life difficult for you, but consider that in the context of bias and be aware of that. Okay?
Quick question for you. So sometimes on a controversial issue, or maybe it's just a business coming in for something or other, the room will be packed. We know we're going to land somewhere around midnight or 2 in the morning, and half the people are there to say, that business owner, that's where I get my bread and butter from. They're nice guys to work for. But everybody comes up and speaks, saying the same thing. Is there any polite way for the chairs of the commission or the board to aggregate those responses and still have them be a valid part of the record?
Yeah, question is one of efficiency. How can you get home before midnight and not have to listen to the same thing 25 times? Actually, there's a point in the outline where I'll talk a little bit about that. And that really goes to what I suggest is it doesn't have to happen every meeting, because you don't always have those controversial things at every meeting. But the meeting that you do, I suggest that you have a whole series of rules and that they be read to the audience at the front end, and that's where we deal with it. And I'll talk about that in a little more detail, but that's one of the rules, the things that when I was a planning commission chair, that I had my little list that, I had the blessing of being able to practice in this area too, so I saw things from that different perspective. So I was in those controversial meetings, I always had my laundry list of things that I read to them and thought we'd all be great. Although I was accused of violating the open meeting law my first meeting that I chaired. We didn't do that, but there's no way to get around some of the contention. There are a couple other doctrines as well that are more technical legal doctrines I don't really want to go into much detail on. So just kind of to summarize, first we've got this broad authority to exercise. We've got the Constitution that says we have to be, I'm going to just give you the rules. We have to be consistent generally in our application and treat similarly situated people the same. We can't use a sledgehammer to kill a fly. We should be fair. We should be reasonable. We can't be way out in left field. And those really are the rules. They're kind of like common sense rules of living too, aren't they? And that's the way we kind of want to conduct ourselves in our orderly, in our personal business, and the same is true in the area of land use. So these are not like super technical concepts or legal concepts, but they're concepts that made their way into the Constitution that governs government. I think people sometimes misunderstand that. I can't violate your constitutional rights because I'm a private person. The Constitution only constrains and empowers government entities. So because we're government, we carry the baggage of, so to speak, having to comply with the Constitution. But all those concepts in there are pretty fundamental concepts that we have to be aware of, and hopefully you've gotten a sense of how they've been applied in the land use context. Then we get into more technical ones. Again, I don't want to talk about them in detail, but there are these legal doctrines called the doctrine of conflict and the doctrine of preemption. And I'm going to try to simplify those without getting into a legal treatise, but essentially what they are doctrines that arise out of trying to define that line between the state's retained authority and the authority that they've given us to regulate the use of land. So in certain situations, a party can argue the county exceeded its authority because that issue is one that is for the state, because they regulate it, and they regulate it enough that the county shouldn't be messing with that. So in simple terms, that's what the doctrines of conflict and preemption are. And in many cases, it's easily resolved for us because where the state has adopted a regulatory scheme, it will say right in the statute, municipalities are preempted from regulating this. So we know, oh, we can't touch that. That's a matter of state affair. But sometimes it's not that explicit, and sometimes that requires us lawyers then to ponder and argue about, is this an area that we can mess with even though the state regulates it on some level, or not? And one area I can think of where, again, we have the benefit of the state telling us what the rules are is shoreland. So if those of you who are familiar with shoreland regulation, the DNR has adopted this comprehensive set of agency regulations and said to counties, you have to regulate shoreland, and here's how you're going to do it. And they have all the standards right in the ordinance. But they also say in one of those rules, if counties want to be more stringent than these regulations, they can be. So they've opened the door for us to exercise, in a sense, concurrent jurisdiction where the state has a broad regulatory scheme controlling that type of land use, but yet we have the ability to concurrently with the state also adopt our own regulations. And shoreland isn't the only one. There are other ones as well.
So isn't that true in general, that the county can be more stringent in regulations than state statute?
No, it's not always true in general because, for example, the case where the statute says the counties can't regulate, we couldn't be more stringent because we just can't do that. And in a case where a regulatory scheme doesn't say we can be more stringent, it becomes more complicated, and we have to consider the breadth and depth of the state's regulation to determine, as the courts say, whether there's any room for the county to be able to regulate. So I don't want to go into that because that's where it gets complicated, but I tried to illustrate the outside parameters of where it's an easy answer where there's concurrent regulation, and then the murkiness in the middle that becomes too complicated. But always be aware that if it's a land use that is regulated by the state, then we have to take a step back and say, okay, is there a place for us here or not? Wind generators is one example where there's state regulation, and they've kind of carved it up based on size. The nameplate, faceplate capacity. You're not in the wind generation, that's further west. But whatever it is, it's based on the size and the amount of energy that's produced. The solar gardens that are becoming popular, I don't know if you've been hit with any of those yet, but they're coming online. There were tons of projects in Excel's queue that they weren't dealing with, and now they're all of a sudden starting to pop out of the other end of the queue. So I'm seeing more and more of those cases. I've got 2 up at the Court of Appeals pending decision, but that similarly is regulated at a state level, but then also at a county level where they've focused on size as a differentiating factor. So that's another example where we can regulate together in the middle. But it becomes complicated. So again, I don't want to go into it, but the issue always is when you have an issue that's regulated fairly heavily by the state, we should always reflect on, is there a role for us on this particular use or not? Yes?
Also translate up to even federal regulations, like in some cases more recently, FRA and some of the rail regulations, or for example, CapEx 2020, when you get large power lines built out, were you involved, and if so, if the answer is yes, you were involved in some of these, part of what you're sharing here, maybe you could touch on some of those cases where it wasn't just state, but there's federal
Yes.
Energy, for example, putting a large power line or something like that, or when the regulations for rail, which can be contentious too, and
Yep.
safety and so on, how that trickles down from state to county to city, and if you've had experience on that as well.
Yep, the concept of preemption very much can apply to federal regulations. I mean, they're the big boys as opposed to the big boys at the states. So if the federal government has comprehensively regulated something, you get involved in interstate commerce issues, it becomes even more murky legally. But it is true that there are instances, and railroads is probably the best example, where our zoning ordinance and our land use authority is very much constrained by the federal regulatory scheme. So we have to be careful of that circumstance as well. Was there another question as well?
In the takings regulations, Canada deny property owner all economic viable use. Does that mean that if somebody applies for a permit and you deny it, and you say you can't do that, but you can do this, they say, well, I don't want to do that. This is what I want to do, and you take it, this opportunity basically. Is all the key words in there?
Yeah, it doesn't matter what the property owner wants to do. The analysis is in a vacuum, not by reference to a particular property owner's desires or wishes. So literally, when we have a takings case and they allege a taking because they can't do X, the exercise is always you can't do X, but you can do Y and Z under the ordinance. So what does the ordinance allow? Not what they would want to do, even if they wouldn't want to do Y or Z. They can still do Y or Z. And that's been construed very broadly. Some of the cases I cite in the material where the courts have said the use of property in its natural state is a reasonable use and it's not a taking. I mean, that's a pretty significant concept, isn't it? So that was a case where someone, in the materials I may discuss it, I can't recall, someone had 2 substandard contiguous shoreland lots, had used the next door lot to be able to have campfires, and they accessed the lake from that lot and had a dock down there as whatnot. Grandkids played over there, they popped their tents whenever they came up and things like that. Court said that's a reasonable use of that property, there's no taking. So that kind of, I included that as an illustration of how difficult it is to make a takings argument. Other questions? Okay, let's shed all the backdrop and the philosophy that I've talked about, and let's talk about meat and potatoes now. And I'm going to talk about the most common types of permits that you deal with. So this is for you Board of Adjustment members, the first part of the conversation before our break, and that's a concept of variances. Before I touch on that, I want to distinguish and mention, at least in passing, because I don't do a lot of it in the outline, but I want to focus on the other function of the Board of Adjustment, of a Board of Adjustment. So one, of course, is consideration of variances. What's the other one? Board of Adjustment members.
Override a supervisory regulation.
Yeah, absolutely.
Decision.
The consideration of appeals of an administrative order, requirement, or determination. So zoning staff says to a landowner, well, you can't do that unless you get a CUP. Landowner says, I don't think I need a CUP. I think this is an permitted use. I shouldn't have to go through that process. An administrative determination they can challenge up to the Board of Adjustment. And the Board of Adjustment is the final authority on those matters, as well as variances too. So that's really a significant power, isn't it? Everything the board, arguably, or many things that administration decides in administering the ordinance, a landowner can then challenge that determination up to the Board of Adjustment and ask the Board of Adjustment to make a determination.
But they can only override an administrative decision, not a board decision, right?
Oh, what a board, county board decision? Okay. What do people think about that? Could you have an ordinance that allowed property owners to appeal county board decisions to the Board of Adjustment? Are you talking about in the land use area?
Yes.
Okay, so a decision to grant a conditional use permit. Let's use that.
The board has made this, developed this ordinance.
Yeah.
Pretty much, and they want to come to the Board of Adjustment and say, I don't agree with that.
Could you, in your ordinance, could you say the Board of Adjustment has the power to consider appeals of county board decisions to grant a conditional use permit?
There's a step before going to district court.
Yeah. Could you do that? Would you want to do that? That's a good question, yeah, because you're putting the decision to grant or deny a conditional use permit in the hands of non-elected people, right? I'm not saying that's good or bad, but it's ultimately the final decisions being made by a body that is different than the body you normally have make decisions like that. I'm not going to argue with you. I'm just trying to throw out considerations. I've only seen one county do that in the state. I can think of one ordinance where for a time they had that step in the process. And I think they changed it because they had a bad experience as a result of that. So it's not the norm. But normally it is by statute. In 394.27, the provision dealing with the Board of Adjustment, it says that its power is to consider appeals of determinations of staff, not of the county board. So there's probably an argument that you'd be maybe in excess of your authority, but I'm not going to spend a lot of time on that. It's just I've seen that once before, and it didn't turn out well for that particular county. So normally it's limited to appeals of those decisions. And then the second authority is to consider variance requests. So what is a variance request? A variance request is literally someone asking to not have to follow the rules that the county board has set up. There's a distinction in the statute and state law between area variance requests and use variance requests. And the statute says you cannot grant use variance requests. So what's a use variance request? You have a residential property, residential zone district, and someone that owns a property in that district comes in and says, I'd like to put in a business here. It's not on the list of allowable uses. Remember at the beginning I said permitted uses, conditional uses. You cannot use the variance process to allow that. That's a use variance. A request to put a property to a use that's not otherwise allowed by the zoning ordinance. So variance requests have to be limited by statute to area variance requests. And those are the requests to those performance standards I talked about, not the list of uses, but the performance standards. So my earlier example, you've got a 10-foot side yard setback. Well, I want to build 6 feet from the property line. I don't want to have to follow the rule that you said everybody has to follow. I want a variance. So that's the meat and potatoes of the Board of Adjustment on that particular front.
One question.
Yeah.
Can the county issue a variance to allow something that the state says you got a 100-foot setback? Can the county give a variance for 50?
Question, can we allow, is there a particular use you're thinking of?
No, I'm just saying
Okay.
that the lesser, in my case, is oftentimes the township has a regulation and it's pretty much the same as the county. Can the township issue that variance? Because it is actually allowing a lesser setback than the county has required. Can the township do that?
I'll talk about that when we talk about the interplay of township and county regulations.
Or
But
the city, the
yeah.
county, and the state?
Yep, your question's too complicated to answer generally, but I'll give you one example where I can answer it, and that's shoreland regulations. So the DNR has said, it has a regulation that says it's got to be, this a house has to be built at least 100 feet from the ordinary high water mark of a lake. Counties can grant variances from that state requirement. There are some additional things that they have to look at, but that's one example where, yes, we can grant variances from an otherwise state requirement that exists. It's almost like that preemption issue. You have to look at it on a case-by-case basis. So it's just too difficult to answer that as a general matter.
I have a question on use versus area density requirements. So like a 1 per quarter scheme, is that a use or an area regulation?
Yeah, there's, I've struggled with that back and forth. I think I've even engaged in conversation with you, Rick, over the years about that, where I think you can characterize that almost either way. Because if you allow them to build 2 per quarter section, you could say that's a use variance because you're not allowed to have a second house on that property. But in the same sense, you can think, well, it's really quantitative because it's a limitation on number. There's actually a case out of the Rochester area that I think suggests it is a performance standard and the proper subject of a variance, but I can't remember the name of the case.
Would the same thing apply to, say, prohibition on building in a bluff? Houston County, we have a more stringent standard than the state, and there are instances where there's not a decline of a toe, so somebody gets within a slope that would be permitted. However, we're calling a toe lower. It's not a district prohibition. You're talking about measuring slope.
Yeah, I think that's the same analysis. I think you can slice that a couple different ways. And I think making a determination and taking a position on that, I mean, that may be the type of decision you make administratively that goes up to the Board of Adjustment, and then the Board of Adjustment has to make that determination. That's one example, if you haven't in your county. But yeah, I think that's the same analysis, and I think you can look at that fairly either way. Yes?
Expand a bit on the last 3 lines at page 7 regarding the appeal of K.
Oh, I don't want to expand on that. That's a murky area. How can I expand on that without digging too deep of a hole? That is a case that dealt with a nonconformity on a lake. And under statute, one of the powers of a Board of Adjustment is to grant relief from restrictions related to nonconformities. That's what the statute says. So in that particular case, the court said, because this is a nonconformity and a Board of Adjustment has broad powers to be able to do that, we think that they have the power to do more things than they otherwise would. It probably doesn't satisfy you in terms of an answer, but that's the best I can do. That's one case, and there aren't many cases that I've run into or areas where I don't understand what the court's saying, and I choose the ostrich approach. I stick my head in the sand and say, I'm going to pretend that case doesn't exist because I don't understand it. It's too difficult. If you have access to those cases and you want to read them, I would welcome if someone can have greater insight on those things. But I've read Kismet and the Appeal of Kinney case and tried to understand what the court was trying to say, and I don't understand it. But I think that was the basis for their decision, and that's the most I can say about it. Now, the use variance is one thing I wanted to just kind of wrap up. That example of where someone came in and wanted to build a business in a residential zoned area, we've established that you can't do that. But what if you as a board look at that and say, gosh, this area has really changed over time and it really makes a lot of sense. What options might you have available? Rezoning, modification of official controls. Maybe you have something like a planned unit development and overlay district that allows you to deviate from the standards legitimately. You can't use a variance to do it, but there are other options available. So I just wanted to make that point where someone comes in and wants something they can't have. Maybe there's another thing that you can do to pursue that if it makes sense in terms of what they're proposing. So let's talk about the standards for the grant of a variance. And I want to start with just clarifying where we're at today, because I actually have a case that was in northern Minnesota that we got bound up in because the county had not changed its variance standards in the ordinance to reflect current law, because it's changed a number of times since 2011. So we have to, as boards of adjustment, we have to make sure we're using the proper terminology. As administration and staff, we need to be sure that our ordinances are consistent with the current standards for a variance, and that we're guiding boards of adjustment in the fashion that leads them through the current standards. So I'm going to start out just by talking about where we used to be in 2010, where we landed in 2011. I might have my years wrong, but then where we landed most recently in the current law. So it used to be, before this Supreme Court case called Stadsvold, which I'll talk about in a moment, it used to be that the concept that we always applied as boards of adjustment was undue hardship. Right in 394.27, it said variances can be granted in cases of hardship. We use the phrase undue as well, undue hardship. But then the county statute went on to say, or practical difficulty. And the city, parallel city statute didn't say that, it just said hardship. Again, one of those weird differences. So we always historically used undue hardship as a standard. Our ordinances said that. We had elements and life was good. And if our decisions were challenged, it was just on the grounds that we made the wrong decision, not that our standards were all mixed up. Then in a case that I had involving Itasca County, someone argued, yeah, but the county statute says hardship or practical difficulty, so they must be different. There must be two standards for counties and one standard for cities. So practical difficulty must mean something different than undue hardship, or the legislature wouldn't have used both phrases in the county variance statute. And in the case I had, the court said, yeah, that's true, but you haven't properly raised it in this case, so we're not going to consider it. So we had a case that said, oh no, it must mean something different, but they won't say how it's different. Then finally, in the Stadsvold case, a number of years later, the court was squarely presented with the issue and said, yes, practical difficulty does mean something different. and here's what it means. And then the court came up with about 13 factors and elements of practical difficulty, which significantly overlapped the statutory elements of hardship, but were a little bit different. And in addition to that, the court said in the Stadsville case, and then balancing all of these factors, what does the interest of justice require, whatever that means. So there was a period of time where we as counties were thrown into this uncertainty where, oh, geez, I guess we're supposed to apply the Stadsville standard now to variance requests. And then a number of years later, and this is, I think, 2011, the years pass by faster all the time, the legislature fixed that. And the legislature took out hardship in the statute. So now 394 says practical difficulty for counties, and 462 for cities says practical difficulty. So we have harmonious standards, and the elements of practical difficulty are the same. So that's where we're at currently, just so that you're clear that the standard for the grant of a variance today, as we speak, is practical difficulty. That's what the statute says. I do it myself. I've given presentations where I still use the word hardship because it's stuck in your lexicon, and I run across longtime Board of Adjustment members who've been on a board for 30, 40 years who can't get off of the concept of undue hardship, and they still use that. But if we can, as we should, practical difficulty is the standard of variances today under the statutes 394.27. And the legislature has largely, the elements of practical difficulty are largely the same as the elements of hardship under the statute that existed prior to Stadsville, so I hope you follow that. So largely we've come around full circle, and we're engaging in the same analysis we always did historically, but we call it practical difficulty. That's kind of the series of events that started in 2008 or so, and then brought us up to the legislature correcting it. So that's more background information, but I just wanted to be sure that you have that history, because I still see counties in Minnesota that are stuck on Stadsvold and the elements. And a decision I got recently up in a northern Minnesota county said that Board of Adjustment screwed up because they're applying the law of 2008. So we have to be sure and apply the laws that exist today. Hand up.
Those 13 standards that were issued by the court, are they in your hand up here?
Probably not, because they're not the standards you should apply. So I don't want you to know those. What you have to know is what I'm going to tell you now. And that is, what are the elements of practical difficulty today? And I'll break it down into a discussion of each of the standards or sub-elements of practical difficulty. The first requirement is that any variance request must be in harmony with the general purpose and intent of official controls. And I would add on to that the comprehensive plan. So the first area of inquiry for a Board of Adjustment is to ask itself, is this variance request consistent with the purpose of our zoning ordinance and our comp plan? Now that seems like kind of an amorphous concept, but let me talk about that in practice. A variance request in a county where a landowner requested a variance from the dwelling setback from a road. This area of the county happened to be a very hilly area, and her property happened to be on the backside of one of the hills. So not right on the top of the hill, but a little bit over the top and down the side as you were coming from this direction as well. So she wanted to build her house closer to the road. In analyzing that request, staff ferreted out and made the Board of Adjustment aware of certain provisions in the comprehensive plan that said whenever land use decisions are made, they should be made assuring the safety of the traveling public and of residents. Well, how does that apply in this particular case? Some of the concerns that were expressed and developed in the hearing process for the variance was that this was a dangerous situation, building a house closer there, because people would come up over the top of the hill and the house would be much closer to the road. The front yard, where people may be present, maybe kids would be playing, and this property owner wasn't going to own the property forever. And remember, variances run with the land. So the right to build a structure would be there, and it may be a family with young kids that buys the house next, who knows. So you never consider that just with respect to this property owner. So they were concerned when the roads are icy, if a car comes flying up over the hill and skids, may take out someone in the front yard, or the house would be much closer and may cause damage. So ultimately, among other reasons, that Board of Adjustment said no variance. This is inconsistent with our comp plan principle that we should make land uses that recognize and take into consideration risks, traffic-related risks. We think this is a risk because, when I talk about findings, I'm going to develop that thought for you a little bit more. I'll bring that example back. And ultimately denied the variance, and the court sustained the denial because the board legitimately concluded that that request was inconsistent with that comp plan principle. So that's one example of that in practice, of how every time you ask a question, I think it's really staff's obligation to work with you and develop those issues, but be aware of your comp plan, be aware of your zoning ordinance. I'm guessing, and I didn't look before I came, but I'm guessing each of your ordinances at the beginning of each district has a purpose statement. It says, here's the reason we have this district, here are some considerations we should look at when we make land use decisions. Whenever you have a variance request, it's those things, the comp plan, that are the things to look at with respect to this consideration. Is this request consistent with our zoning ordinance purpose and the statements and goals and objectives in our comp plan? Yeah.
Mr. Squires, did I hear correctly by stating that when considering a variance, what's really important is not the requester, but what the effect of the request would be upon the perpetuity of the land itself?
Yeah, and an example of that, and I'm going to get to that in one of the next standards, is the statute talks about the circumstances unique to the property, not to the property owner. So whenever a variance request is made, it's the property that is the focus of the analysis, not the property, or like our discussion of taking, not the desires of the property owner at that particular time. And that's the concept, again, of variances like conditional use permits run with the land. So this permission you're giving is forever. It will survive the ownership or the life of the person that is applying for the variance. So I think necessarily your analysis has to be, do the circumstances with respect to the land justify the variance?
I think it's just a general thing, but had the county in that situation granted variance, and had there been an accident, would the county in any way be liable, considering that they granted the variance of good faith, thinking liable?
Yeah, let me rephrase your question. Should considerations in the fear of liability guide our decision or inform our decision making in the land use area? And I would submit no. We have many immunities that protect us when we make permitting and licensing decisions that I don't believe we should ever be giving permits or not giving permits out of fear of county liability. I think we should apply the standards and make a decision. You'll see when I'm talking here, one of the statutory standards is, and might the county be liable if there's an accident? That's not in the statute. So I don't think we should worry about those things. Another question?
As a resident of Houston County, I happen to share that with our county commission stated here to be consistent or thoughtful of comprehensive plan. That's not just the county comprehensive plan, but truly DOAs and planning commissions should be aware of and perhaps in some cases research each municipality or city or township's comprehensive plan. That could be some work, but you have to be thoughtful and considerate of their comprehensive plans. Is that correct, Glenn? Or
I
you
don't,
say
yeah,
it's the county
yeah, I don't know that I
comprehensive
agree with that completely. I think the statutory standard contemplates the county's comprehensive plan. So I don't think it's the role of a board to research more broadly into other comprehensive or regional plans necessarily as it relates to this particular item. I think it's focusing on the county's comprehensive plan.
Thanks.
Any other questions about that element, about the comp plan and official controls? Second element is then that requirement is kind of stated by itself, and then the statute goes into practical difficulty and what it means. So that's part of the analysis, but now let's talk about the specific aspects of practical difficulty. First one is the reasonable use component. And this used to be, and I'm just going to provide some background, be cognizant of it, and then forget about it because I just want to put it in context. For a while, there was a case from the Supreme Court that said that you couldn't get a variance unless you could prove that you couldn't put the property to any reasonable use without the variance. That's a really high bar, isn't it? Because that's kind of like our taking analysis, isn't it? Well, you can do this. The Supreme Court said that's what the variance statute meant, which would, I think, disqualify many variance circumstances. That wasn't for a long period of time. That was just before that 2011 change where they plunked in practical difficulty. The legislature also dealt with that problem and reversed that Supreme Court decision. So now what that means is not that taking thing, so forget about that. It's not the can they do anything else with the property that's reasonable. The question that a Board of Adjustment asks itself simply is this request reasonable? We lawyers love the word reasonable because it keeps us in business, doesn't it? That's why you have two lawyers on both sides of a fight, because we argue about what's reasonable or not. Who knows what's reasonable? It's like beauty. It can different people can define it different ways, but literally that's the question that you ask: is that reasonable? And I'm not going to give you a definition of reasonable because there isn't one. It has to be a decision that you make applying the norms and mores of your community, whatever those are, and your experiences. But let me give you an example that might put it in context. This was a variance case up north, northern Minnesota lake, beautiful lake, scenic, nice, reasonably sized, consistent sized cabins alongside the lake, 1,000 square feet, 1,500 square feet in size, all lined up in a row along the bank, set back. Though at that time, most of them were really close to the lake. These were set back further, allowing a very nice view that everybody would have down the lake to experience all the beauty. And City Slicker goes in there, who has a lot of money, and he has always, since he's been a boy, he's always wanted to have a personal lighthouse. It's been his dream. And now he's got enough money to have one. So he finds this lake, and he wants to build a 10,000 square feet, buys a number of lots that are vacant next to each other, wants to build a 10,000 square foot house, and he wants to put his personal lighthouse down at the shoreline so it can zip with the light, and he can sit in his big lofted master suite and see the lighthouse light and self-actualize as a result of that. So with all those facts I've given you, is that request reasonable? Yes, no. I'm not looking for an answer, but just trying to put it in context for you. So what does reasonable mean? Reasonable means, what else is happening? What are the normal rules? What's the history? What are the norms, as I mentioned, and mores of our community? I can't do much better. I can't define it for you other than just give you an example where you might say, well, that's just not reasonable. So ask yourself, okay, you're thinking, I saw a lot of head shaking. No, that's not reasonable. Why are you thinking that way? If you can think through that and in your own head, think through what things were important to you, that's the analysis. And that's probably the best I could do. But that's the second question that you ask. Is the request reasonable? The third question is the plight of the landowner due to circumstances unique to the property? We just covered this, remember, in that question. Unique to the property, not created by the landowners. There's a lot of stuff in that one sentence that I want to cover. First one is the concept of plight. And this is a case I actually have. It's the same case where they had the Stadsbold standards. Ultimately was resolved, so we'll never see an appellate decision. But does there need to be a plight for someone to be able to apply for a variance? It seems to be the case from this sentence, doesn't it? It contemplates the existence of a plight. The plight is due to unique circumstances. I'll talk about that other stuff later. So what if the landowner can meet all the standards in our ordinance, but the landowner just happens to not want to? Sure, I can build a cabin at 20 other places on my property, but I want to build it on that hill that's 25 feet from the shoreline because that gives me some kick-butt views of the lake. I would like a variance. Does that landowner have a plight? What do you think? That was my argument in the case that we'll never have an appellate court resolve, but this is where I'll harken back to Stadsvold, where it might have been helpful to have the materials in there. Remember those 13 factors? One of the factors the court said was the feasibility of alternate locations not requiring a variance. That's exactly what I think plight means. I think there's no plight if there are feasible alternatives. So that's the first thing I think we can still legitimately ask ourselves, and then when you're sued, please ask me to represent you and I'll make my plight argument again. I think it's still legitimate for us to say, are there options available to you where you don't need a variance, where you can comply with the rules? Because if there are, I would say, there's no plight.
But if the landowner has another reasonable option, but he doesn't want to go there for maybe economic reasons, saying that maybe that land's more valuable than this land. I mean, how do you sort that out?
Well, that'll get into the last factor. Hold that for a moment when we talk about what role money plays, and I think it mixes in with that. But let's break this down a little bit more. The plight, let's assume there is one, must be due to circumstances unique to the property. So again, we covered that already. Unique to the property, not unique to the person. The one exception to be aware of, just as if someone comes in and says, I need a variance because I'm disabled and I can't live on this property unless I get it, that's a unique situation. It involves other laws that we have to be cognizant. So that's the one example where it might be something to do with that person, but unique to the property. So is there something about the property that militates for need for the particular variance? Is there a bedrock, a deep bedrock outcropping that forces the need to be able to put a dwelling in this structure, etc.? So the focus is on the property, not the person. And finally, the third piece of that, when you, I think, break this down in analysis, is if there was a plight and it involves the property, nevertheless, did the landowner create the circumstance? So the example I use, again drawing from these actual cases, is a variance request from a landowner, again on a lake, that these seem to be the most common, where the landowner was a landscape contractor who also happened to specialize in water gardens, so he built these really cool fountain flowing things. And he bought a cabin and he built this really cool thing on the side that was wide open where there was plenty of room for it. I forget the direction, west or something like that. And then he came in a number of years later and wanted to build an addition to the cabin, but he couldn't on the west side where the water feature was, so he needed a side yard setback to put in an addition because his kids had now started having kids and they didn't have enough bedrooms to put the grandkids in. So he wanted the variance request. So in that case, the question for the Board of Adjustment is, was this problem created by the landowner? Certainly the result of a choice of the landowner to do something. I suppose he could rip out his water feature and put the addition there, but the product of a landowner decision, or as the statute would say, a self-imposed hardship, something the landowner did that created the need for, or contributed to the need for the variance. I was asked once, does that run with the land? So is it only that landowner that caused the problems, or do we hold the future owners of the property accountable? I don't know the answer to that, but I think it runs with the land.
Does it extend to the past, the previous landowner?
I think all the circumstances, decisions that have been made, I think you're asking the same question I am, just looking at it from a different perspective. I think it's too easy to be able to transfer the land and say, sorry, I'm not subject to the sins of those that owned it before me. I think under law you are, because it would just be too easy to do something terrible, transfer it to someone else and say, oh, now I get a variance. So I think that's an improper workaround. So I think that runs with the land. If that argument is ever raised by you, well, I didn't do that. Someone that owned the property, two people before me is the one that did that. Well, that's a decision that was made that runs with the property.
I'm not sure I understand what you're saying. What's your conclusion?
If you poop in your bed, you have to sleep in it. If you poop in your bed and you sell the property to someone, they have to sleep in your poop too. That's what I said in essence.
Back to the water.
Oh.
Back to the water part, where do we have?
Uh-huh.
So, are you saying that he should get a variance?
No, that Board of Adjustment concluded the hardship was self-imposed. It was caused by the property owner, and they weren't entitled to the variance because it was a product of the decision the property owner made, and the reason the need for the variance was created by that decision that they made about their use of the property. That was never challenged in court, so I use examples, but don't always have a court decision that upholds or doesn't uphold it.
So you're looking at a piece of property that needs a variance, you want to build a garage for whatever reason needs a variance, and you know that, and you buy it, does that mean that you cause it, or, can you buy a property you know it needs a variance and expect to get a variance?
There used to be a case that said, so if you have knowledge that there's no room on, let's say, the west side to build an addition, and then when someone comes in for a request, can you say, oh, sorry, you can't even apply, you're disqualified, you knew or should have known that circumstance existed. There used to be a case that said that, yes, that was true. If you bought property knowing of that problem, or even if you should have known it, that you couldn't get it, you were automatically disqualified, but that case was reversed. So is it a factor that you look at? Yes, as we're just talking about now. But does it mean automatically they don't get it? No. You still have to go through the analysis.
What if he just wants to build a garage closer to the property line because it's just easier for him? He wants more of the land available up front. I mean, we've had those arguments too.
Well, that goes, it's easier for him and it gives him other opportunities with other land. That goes to the discussion we had previously, doesn't it? What other alternatives do you have where you can meet the requirements of the ordinance?
How do you come down on that? Do you weigh that? How do you weigh that?
My job is to instruct you on what the standards are. Your job is to make the decision. My job is not to make the decision for you. When I look at things in a vacuum, and I can only look at them in a vacuum now because that's where we are. I'm not faced with a particular request. I'm telling you what the statute says in my reading of the statute is that because it assumes in your example a plight that if they can construct things, place them reasonably in a location that doesn't require a variance, I think that's a factor that should go to whether they get the variance or not. Now, hold that thought because you asked me to talk about economics too, and I'm going to put an asterisk on that as well.
Just expanding on that, Ryan, there's the city of Clinton.
Yeah.
We have a property owner that comes in with a potential buyer who wants to do something that is going to require a variance. But that potential buyer could buy other parcels anywhere in the county or another county. But that potential buyer scheme is dependent upon a variance and has the seller willing to go in and apply for the variance. How does that play out with the old rule and the new rule, would you say?
Well, I don't think the fact that there's a buyer that's interested in a property, but only if they get a variance, really has any bearing on our application of the test. All the factors I'm talking about would apply equally. If they're seeking, now I'm assuming in your scenario, hypothetical, that then the current owner actually applies for a variance. The buyer is buying the property contingent on the variance being granted, which is what I would tell the buyer you should do, representing them. So now you as a Board of Adjustment are considering whether that variance, let's just say for sake of example, it's to build a structure 5 feet from the property line instead of 10. So that's the variance that's before you, so you ask all these questions. It doesn't matter that scenario I think you're presenting. It doesn't matter how that's structured. It's still the same analysis. That kind of goes to almost the needs and desires of what's going on. I mean, we put our blinders on and we look at the property. Here's the request. We look at the property and apply the test. Next, I want to get through variances and then we can have our little break I promised you. Next question, the variance must not alter the essential character of the locality. There's more work for lawyers here too. What's the essential character? And what's the locality? We can parse words and ask questions about it. So I think there's a couple of things to look at in this sentence. Again, let me give you an example. Another lake. I have to think of some non-lake examples, but they're always the good ones. A property owner applies for 3 variances to a boathouse setback, to the width of stairs, and to a patio up on the top of the lake. They're denied and it's challenged. She happens to live on a lake up near Leech Lake. Anybody know Leech Lake? You know how many bays there are in that lake and how some bays, each bay has almost a different character and a different feel. This wasn't Leech, but it was a lake up by Leech that had a lot of little bays too, different character in each of the bays. And in the particular bay that she lived in, on top of that, it was a common interest community where there were covenants, if you're familiar with covenants, that also had a bearing. Do you apply covenants? Are you interested in covenants as a land use regulator? It's not your fight, is it? But they had covenants, so they act on top of zoning ordinance requirements. And the effect of those covenants was that the character of this bay was very natural environment-y. So while on other parts of the lake, you'd tool around in your pontoon, drinking your beer, and you'd see people sitting on the end of their dock with their boathouses a foot or 2 off the water and everything very close. But this bay was very different. You could hardly see anything as you went by in your pontoon. It was very vegetative and screened, and things were set back. So she applied for a variance to those things, and one of the things the board denied it, and one of the things the board said was, this will alter the essential character of the locality. So that then raised the questions, what is the essential character? So in this particular case, the court said, well, the essential character, and she came around, by the way, in the variance process, she took pictures of every single boathouse on the lake. And she was armed with them at the Board of Adjustment hearing, and she plopped 58 photos down on the desk and says, this is what I want to do. Everybody else on my lake has a boathouse 10 or less feet from the water, and I just want to do what everybody else wants to do. That sounds familiar, doesn't it? What you've let everybody else do, whether that was true or not, I don't know, but that's what I want to do. And the board said, well, that's all well and good, but those are other areas of the lake. Your bay is different. Your bay, because of the operation of the covenants, has a very natural environmental feel. And to allow you, now, she may not have been able to do this anyways with the covenants, but just looking at our issue, to allow you under our regulations to build that stuff that close to the lake would just change the character of this particular bay. So that's the essential character, natural environment, screened vegetation. The locality was not the lake or the neighborhood, it was the bay. So the two elements of that sentence or that standard, and variance denied, and that was upheld by the court. That was actually challenged and then upheld by the court. The one instance where the lady was so mean-spirited in the courtroom that she came after and tried to attack me going out the courthouse, and the judge had to sick the bailiff to tackle her. Wow, this is just a land use case. Yep.
And that was dependent on them.
Yep.
Which was that they were going through attrition. I mean, I think the DNR approach with the boathouse communities was ultimately attrition to get them to remove once they went through their life cycle. But because we went through a resolution process, they're allowed to continue.
Yeah. We represent the city of Red Wing, so I know how those communities operate, and there's very much history involved in those on-water communities.
Jay, could you give us like 60 seconds on what is a covenant and where do they make sense, or if they make sense?
Yeah, a restrictive covenant is one that's imposed by property owners, so they're private in nature. Whether it's when a common example is when property is platted a new residential subdivision, they'll have covenants that govern the colors you can have, fences, all kinds of things like that. But technically, any property owner can impose covenants on any piece of property. So I sell you a piece of property. I'm gonna put some rules on what you can and can't do with the property. I could do that in the deed. So a restrictive covenant are private use rules or limitations or restrictions that are enforced privately. So the county is the land use regulators. That's why I said we don't really care about those. That's your fish to fry as a private property owner. Sometimes landowners want us to get involved in those things, but they're not our ball of wax. The last thing, and then we'll take our break, last element of variances is the element of money. What role does money play in it? And what the statute says is economic considerations alone do not constitute a practical difficulty. So let's look at those words the statute uses again. Economic considerations alone. The legislature, there's a tenet of statutory construction saying the legislature doesn't put words in statutes that don't mean anything. So the courts say every word has a meaning. So the fact that the legislature inserted the word alone means arguably that money can play a role in a variance decision. So it's not totally taboo. So don't take the position that, oh, this is, you just mentioned money, it's all about money, variance denied. I don't think that's what the statute contemplates. But that then begs the question of what role can money play? And here's my advice to you with no case law support, but I think it makes sense to me. And that is that I believe when faced with it, a court would consider how much money and how big of a variance. As I think about all the factors that might be considered, those are two that I think might be most important where money is the issue. So let me try to put that in an example. Again, asking you the question, but not asking you to answer it, but hopefully giving you an analytical approach. An example of a property with a significant outcropping of bedrock that has an impact on where the lot or where the house can be located. The property owner comes in and applies for a variance to locate closer to the lot line than allowed to avoid the bedrock, and says, I can save money. My contractor says I can save money if I can put my house here instead of there at the setback, because we'd have to jackhammer all that bedrock out. And you ask the question, how much money would you save? So let's assume that it's a 100-foot setback and he wants to build 50 feet back, so 50-foot variance request to the 100-foot setback. He could save $5,000 in the project. Is that situation different from had it been a 5-foot variance request, and that gets him just beyond the outcropping, but he would have saved $50,000 instead of $5,000? Would you look at those two situations differently? If you're shaking your head yes, I think perhaps the analytical approach is, as the size of the variance increases, it has an inverse proportionality to the amount of money on the table. So in my two examples, those were the two variables. So how much money will you save? How significant is the variance request? Along with these other factors we're talking about, I think is the approach when it comes to money.
Okay, question on measuring setbacks. What's your advice for how to determine how far back we are from the property line? Is survey in order every time there's a variance request? Or do you go by GIS information? Do you go by fence lines?
Yeah. I've had that question more than once, and the general sense I get when the practice of a county requiring a formal survey every time there's a land use request is, oh, that's so expensive, that would be a burden on our citizens, we shouldn't do that. That's a decision you have to make. I think on a case-by-case basis you might require it. I've seen resistance to having that as a practice in every variance. I think at a minimum, it should be the property owner that carries the burden and represents to you that the information they're providing is accurate. Therefore, if I'm the property owner and I'm applying for a variance, I'm going to say, I'm going to go out and get a survey, because I'm not going to build this addition and represent to the county it's set back the 6 feet I'm getting permission, and then have someone come and measure it and find out it's 5 feet. I mean, I'm not going to do that. That's due diligence, I think. So I think at a minimum you should always have it be their burden, and they represent the accuracy of the information they're giving you, and that their structure approved by the variance will meet that setback requirement that the variance allows. Then it's their burden. That's how I would approach it.
Could you give us a
decide if we should recluse ourselves from a particular hearing because of relation or friend or money.
You want me to address that? You would like me to address that topic?
Yeah, I'm just curious
Okay.
if there's some rules we should go by.
Yep, there's a statute on conflicts of interest that govern county appointed and elected officials. It says you can't be financially interested in a contract lease, and I forget the exact language. But there has been precedent saying that doesn't apply in the land use context, so a permit is not one of those things. So we don't want to follow the statute that talks about conflict of interest, but there's a whole doctrine, a body of common law called common law conflict of interest, where it has, and I hate to throw all these 13-factored tests on you, but it is something like a 13-factored test of whether you have one or not. But to boil it down, it's essentially where your loyalties would be divided on a particular issue, then you may have a common law conflict of interest. The cases say that can be solved by you abstaining. So in a case, you have to make, if you believe, obviously if you're an applicant for a permit, I don't think it's one you should be voting on. If it's your brother, maybe that's too much. If it's your cousin, or if it's your second cousin, you'll have to make that determination. You always are free to abstain on a matter, to either, and if you think there's a conflict, you can always talk to the county attorney. Is this something I have to stay away from? You always have the right as a board member to abstain because you feel there may be an appearance of propriety. It's a way to stay squeaky clean. You may not have a conflict, but people in the community may say, okay, he did that because that's his cousin. So you may, to avoid that talk, you may just say, I'm not going to be involved in that, and that's always your right on any given case.
So would you still participate in the hearing? Or just not vote?
Usually if you are going to disqualify yourself, I think it's best not to participate at all. I mean, some people even, I've seen them get up off the dais and go walk into the audience and sit down to really avoid the appearance. But minimally, if you decide that's the situation, I think you should not participate in the discussion or the vote. Because one says for you to participate in the discussion, you can be directly or indirectly attempting to influence your colleagues, which is a problem itself then. So those are your options. We're just about at 6. I want to mention I want to go through this again and just wrap it up. Practical difficulty questions we ask as a board member. Is this in harmony with our zoning ordinance, our comp plan? Is this reasonable? Is this variance unique due to unique circumstances? Is this plight? Is there a plight? Is it due to unique circumstances relating to the property owner, not caused by the property owner or a predecessor in title? Will this alter the essential character of the area? And what role does money have in it? That's your test. There's 2 final thoughts and we'll take our break. After the fact variances, remember that old Stadsville case I talked about? The Supreme Court said, and if it's an after the fact variance, here are a few other things you should look at. It's not clear under the law if those after the fact standards survive the adoption of the legislation. So I can say some counties in the state, whenever it's an after the fact variance, and by that you know what I'm talking about, someone went ahead and built the house and you caught them and now you're making them go through a variance process, so it's already there. The court said in Stadsville you should apply these additional factors. Some counties take the position they still exist because the legislation didn't deal with them, so after the fact they ask those additional questions, some don't. A decision you'll have to make, no case law on it. Did I go out? Yeah, exactly. Wow, it's time to exactly 6 o'clock. Well, I'm back on, I think. On page 10, also, you can impose conditions. Sometimes this is overlooked, but just like conditional use permits, we have statutory authority to impose conditions on variances if there's a nexus. and then they have to be recorded as well. If a variance is challenged, I'll talk about this at the end, it goes up to district court because there's a statute that says it goes up to district court, unlike, for example, a CUP decision, which goes right up to St. Paul to the Court of Appeals panel as well. So that's it for variances. We'll take our break, come back and talk about conditional use. We picked up at, or we left off at page 11 on the outline, and I'm going to pick up with the discussion of conditional use permits. So we're going to move off the Board of Adjustment, meat and potatoes, and talk about conditional use permits. Under state law, counties can empower planning commissions to be the final authority on CUPs. I don't think that's the case in Houston or Winona. Cass County, they do it, and I think a couple other counties. So typically, the typical situation is planning commissions are advisory on conditional use permits. So this is your meat and potatoes. Planning commission members, you have the unenviable task of having public hearings on contentious matters and getting beat up on those things, and then devising a recommendation to the county board. So just a little bit first about the concept of conditional uses. Again, remember that structure of the Euclidean zoning ordinance, permitted uses and conditional use permit uses. And as I mentioned, the designation of something as a conditional use is, or in theory should be, an indication that the county board has legislatively decided there's something about that if the wrong person does it, there might be problems. So we're going to make them go through a process. We're going to have a public hearing. We're going to solicit comments and have a greater degree of scrutiny and the ability to impose conditions. So let's talk a little bit about how you make conditional use permit decisions. Unlike variances where the statute says, here are the standards, as I discussed just before our break, the statute, the provision in Chapter 394 that talks about conditional use permits gives us zero in the way of standards for conditional use permits. So the standards for a CUP are the standards that you adopt. If you're familiar with your ordinance, go to the zoning ordinance and probably the separate section on conditional uses, and it will tell you, here are the standards that will apply to conditional use permit applications. Some similar concepts to variances, the impact on surrounding properties, glare, odor, noise that might arise from the uses. Oftentimes, negative impacts on property values are mentioned. That concept of consistency with the comp plan is often a standard within the ordinance. So we look to our particular ordinance in making a determination about whether we should grant the permit or not. And the analysis really is the same. So I don't have your ordinances in front of me, but literally as a planning commission would be looking at making a decision, there should be a process where the commission analyzes each of the elements of the conditional use permit standards under your ordinance, and then applies the facts that have been generated in the process and determines if that particular standard has been met or not. Just like variances, we can impose conditions on conditional use permits. If it's a CUP, I think even more so now, that unanswered question I mentioned earlier about can we impose a time limit, I think it's more dubious to do it now, because now we have express authority that gives us the right to use interim use permits where we wish to impose a time limit on a particular use. So I don't know if in Houston and Winona you take full advantage of interim use permit authority, but it's something you might think about. I once had a county ask when that interim use legislation was adopted. Essentially, interim uses are just like conditional uses. In fact, most counties say the standards for an interim use permit are the same as the conditional use permit standards. So the one difference just is that you have that additional feature to be able to impose a time limit. So with that discussion, someone in a presentation once asked me, well, why the heck do we even have conditional use permits anymore? Why not just have all interim use permits? Same thing, except it has the additional feature that we can use in a given case or not. I have to say that's logical to me. I don't know of a county that's done that. I think it's more common for counties to just identify those particular uses that are allowable that they might want to impose a durational limit on or make it personal to the property owner. But that's a fair question. So a thought. Yep.
We not only put a time limit on them generally, but limit them to the individual. They're not transferable.
On interim use permits or conditional use permits? Yeah, and interim use permits, I mentioned the durational limit, then yeah, you can make them personal as well. So which in effect is a durational limit. It will be good as long as you own the property. So it's kind of slicing it two different ways, but that is the authority that you have. So, that's maybe you wouldn't want to apply it to every conditional use permit, but you do have that flexibility if you throw things into the interim use hopper under your ordinance. So food for thought. Just a couple of issues that arise in conditional use permits that I want to throw out for your thought. Is it enough when we apply the standards for a conditional use permit? Do we do it with blinders on? In other words, do we ask ourselves, is a standard met, yes or no? And if one is not met, do we automatically deny the request? Let me give you a hypothetical to illustrate the point I wish to make. Someone applies for a conditional use permit for a home occupation. Do you know what that is? Where someone wants to operate something that's kind of business related in a residential district in their home, cut hair in the basement, make cabinets in the garage, a retired person who was a cabinet maker. So you have provisions in your ordinance probably that allow that frequently as a conditional use permit. So someone comes in, applies for a CUP, and the neighbor comes in and says, I've heard him cutting those cabinets in the garage, and that saw is really very high-pitched, and I can't sleep at night. I'm opposed to this. Do we hear that information, and do we say, oh, permit denied? Or is there another option available to us? Gave you a hint at the very beginning of the presentation, hours limitations. So I think there's been some case law and some interesting discussion about whether we have a legal obligation to consider conditions and whose obligation is it. And at the bottom of page 12, there's an interesting legal discussion we've included that ends with a recent Supreme Court case saying it's really the property owner's obligation to offer up conditions. So in my hypothetical, might this case stand for the proposition that we could say, oh, sorry, permit denied, and it's the property owner that has to say, wait, I'll stop my sawing at 8 o'clock. I still think it's good practice for us as we make conditional use permit decisions to always ask ourselves if a standard hasn't been met. A second question, can we satisfy our concern by the imposition of a condition? So if in my example we say, yeah, but we can impose a time limitation, then is that something we ought to do? I think that's maybe just a fair practice approach to considering CUPs. So the analytical structure of the approach is apply the facts to the conditions, decide if they've been met. If any particular standard hasn't been met, can we impose a condition that satisfies the concern we have and balance the interests of the property owner in being able to use their property for something with the potential impact that we see with a conditionless permit. So that's, I think, food for thought that I've seen more than once. And then the second one, just an understanding that I think is a misunderstanding, because I often see in ordinances this periodic review of conditional use permits. Do you have that in your ordinances? Where CUPs will be periodically reviewed. Oftentimes that leads to a belief that after we issue a permit, we have some ability to be able to pull it back. or even worse, to be able to just impose new conditions as we decide are appropriate. And that generally is not the case. We have one opportunity to impose conditions on a CUP, and that's at the time it's being applied for. I cite on the middle of page 13 the Upper Minnetonka case. That was a situation where back in the old days when we were more trusting of each other and we didn't have to put everything in writing, the city of Shorewood issued a CUP to a property owner that allowed the dockage of boats. Well, this was a property that had historically been used and was used at that time for sailboats on Lake Minnetonka. Well, the property changed hands and was acquired by a club that had these super high-speed, super noisy cigar-type boats that they wanted to dock. And of course, all the neighbors freaked out about that and said, geez, and they looked at the CUP and said, well, all it says is they can use it for boats. It doesn't say sailboats only. And then the city said, well, that's a problem, so we'll just change that. We'll impose a condition that says sailboats, and notified the property owner. The court said, no, you can't do that. You had one bite at the apple, and you can't unilaterally add conditions. With an asterisk, I had a case involving Lyon County a number of years ago where it was a feedlot, and the guy discharged, I forget, 150,000 gallons of liquid manure into a tributary to a public water. And the board was faced with revoking the feedlot permit, and they tried to work out some revised conditions that would address that situation. Couldn't do it. Board said, at the revocation hearing, said, you know what, we're not going to revoke the permit, but we're going to put on these conditions to deal with this release. And the court said we had the right to do that. So you can't unilaterally impose conditions, but if it's a scenario where you have the right to revoke, the facts suggest you have a right to revoke, to impose a lesser form of discipline is something that, at least in this case, they said we could do. So just be aware of that in terms of our ongoing enforcement of existing conditional use permits.
Jay, with the existing permits that are older, that have that periodic written in, if we were to issue those today, we would issue them as an interim. But that wasn't an option at the time.
Yeah.
How are those to be handled then? Do they, we can't transition them into interims because they're conditional use permits, but they were granted with the condition that they're reviewed periodically? Yeah,
well, in Houston County's case, the issue, what does periodic review mean? Does it mean that you can do anything with it? That's the question. I think I've looked at that language in the past. And I think it's difficult where you have just general, this will be reviewed every 5 years. It would be difficult to say, oh, we've decided you can't have that anymore.
What is the gain by reviewing it at that point?
Good question. Usually, periodic review processes are to just simply create a process where we are forced to look at it, consider whether they're complying with conditions that might have been imposed at the time, a tickler system of sorts. Otherwise, if we don't have that, then we don't do anything. And 20 years pass and we don't know if they're complying or not. So it forces us every so often to say, okay, let's analyze this. Are they meeting all the requirements we imposed on them? That's typically what the process is.
And if they're not, we don't have an option to add a condition. We have the options are revoke.
Yeah, if someone's not complying with a condition to a conditional use permit, they're in violation of the permit, so we have whatever remedies our ordinance gives us. Criminal prosecution, I suppose, in theory, mandamus action in district court forcing them to comply with the conditions, or revocation.
I've got a question. Can you put a contingency in there, as in contingent on a person having a certain license to do something? In our case, it's a firearms practice range, and he's a licensed firearms instructor. And it's contingent on him maintaining that licensure, that certification.
I think you can. The only limitations, as I mentioned them in the materials on conditions, is that they have to have some nexus to the CUP and the nature of the concern you have, a connection. So in your case, this is a firearms range. You've determined it's important to you to have someone that has up-to-date and current instruction and training in operation of guns, and guns are dangerous. That seems to me to have some connection to the concerns you have that this could have a negative effect on the public. So that's the nexus requirement. So I wouldn't have a problem arguing that's a fair condition, and certainly conditions, oftentimes like our periodic review, they talk about things that happen in the future. You know, they have to annually submit this or do this and provide, you know, evidence of that. So I think that's a fair condition. There's a question in the back.
I'm probably dragging you back a bit, but on page 12,
If it deals with the Henry Kenny case, I'm not going to answer your question.
top of page 12, paragraph D, I think I understand it, but it seems that could be an impossible bar.
No, it's not an impossible bar. I think it deals with
It certainly depends upon
Yeah.
how one defines reasonableness.
yeah, well, yeah, and again, we lawyers like that word. I think what this principle in the RDNT case said was addressed, the issue it addressed is who carries the burden? Is it our county? Is it us as a county that carries the burden of demonstrating that this will be harmful? Or can we in our ordinance say they have the burden of demonstrating that this meets all the requirements of the ordinance? I don't think that's a high bar in my mind to say the landowner has the burden of demonstrating these standards have been satisfied.
So I see performance standards would be the balancing factor there.
Yeah, the standards for the permit. Yep. Well, for the CUP in your ordinance. It's, I actually like to have language in there that puts the burden on the applicant to demonstrate that those standards have been met. They're the ones that want the permit.
But how to be able to prove they'll never harm anybody is another thing.
Well, I don't think that, I can't think of an ordinance that I've seen that says they have the burden of proving it will never harm anybody. I think the inquiry is always based on the facts that are presented. Is it, would we determine that this use is likely to cause harm or be injurious to the public? Yeah, I think if your standards are written so scrupulously that they have to demonstrate something that can't be demonstrated, that's problematic itself, if that's your question. And that's not, maybe we had poor verbiage in that little statement. I'll take a look at that. But I think that's what it's intending to say is it's okay for a county and its ordinance to say the applicant has the burden of demonstrating that the standards for a CUP have been met.
Somebody proposing to build a house up on a hillside, an opponent comes in and claims, well, that might harm my son.
Mm-hmm.
And I'm supposed to prove that won't harm the spring?
Well, hold that thought when we get to the end of us making a decision and weighing the value of evidence, and I'll answer your question. If I don't raise it again, remind me. I'm going to zip through just some subtopics, just for the sake of time and the fact that I want to beat that storm that's moving into the cities right now. Moratoria, just to mention that in passing. I don't know if Houston County has adopted one as I recall, but I believe Winona in its study process on mining had a moratorium for a while, if I'm correct. So that's what I'm talking about, the statutory authority of a county to be able to put a freeze on a particular land use or uses. A pretty broad authority, but one that we expressly have by statute. Again, as I mentioned earlier, make sure we have our terminology correct. Moratoria are often called interim zoning, but that's not the same as an interim use permit. So they're two different things. So moratoria, interim zoning is the particular term. So we have the ability to do that. It puts freeze on whatever we describe as the scope or application of the moratorium. We have the statute giving us the authority says 1 of 4 conditions must be met. This is at the bottom of page 15. We're conducting studies. We've authorized a study already. We've scheduled a hearing for the purpose of amending a comp plan or zoning ordinance. And then this wouldn't apply to counties, more cities, the annexation of new territory. So those are the circumstances under which we can adopt a moratorium. So whenever we've worked with county clients in adopting one, we always make the necessary findings and assure that either prior to that time or in conjunction with that the county is directing the study of that particular property use. So we have the ability to do that. We can do it for a year. We can extend it to an additional year as well. A couple issues come up with respect to moratoria I wanted to mention. One is the question of what does it apply to? How does it apply to pre-existing applications? Because oftentimes the reason that you choose to adopt a moratorium is someone has made a request for a particular land use where you say, oh, our ordinance doesn't do enough on that. We have to stop somehow and study that and then adopt some new provisions. So does your moratorium apply to something where someone has been quick or smart enough to get an application in the hopper, and it's the application that causes you to realize that you need the moratorium? And the answer there is we decide. There is a case that says we have the authority to apply a moratorium to a request or an application has been submitted, obviously, before we've made the final decision. So we can't retroactively pull something back because we adopt a moratorium. But something that's in the hopper, we can apply our moratorium to that. We just have to be clear that the language of the moratorium says it applies to everything for which final approval hasn't been given by the deciding body in the county. And then the second issue that arises, and this is a matter of assuring that your record is structured in a way that you're not accused of this. There are cases that say a moratorium cannot be used as a sword, in particular to kill a particular project. So we can't use a moratorium because we want to kill one project. We have to have a good faith, we have to be engaged in a good faith effort to evaluate and study the use and to ultimately consider the adoption of new amendments and new changes to the ordinance. And that's where, again, I think it's just a question of how you structure your record. You don't want to go off record as saying, we should adopt a moratorium so we can kill this project. If that appears in your minutes, that's going to be a bad fact for us. Rather, work with staff and the county attorney to structure it in a way where you have the discussion of what options do we have here, how good are our zoning ordinance provisions, what do other counties do, can we find a consultant to help us on this, what options might we have, how long is it going to take to study that. That whole process, if it's reflected in the public record, lends support more to the notion you're not looking to kill this project, but truly you believed you got caught with your pants down, and you're engaged in a fair process to try to make sure that you have regulations in place. But be aware of that, because I've seen that argument made multiple times when a moratorium has been adopted. You're just doing this to kill this project. Any questions on moratoria? I'm going to be picking up speed now as we talk about particular things, so feel free to stop me. Nonconformities, another area that is worth talking about. And I'm really, as I go through these things, I'm going to hit the issues where the areas where we see issues recurring, just to highlight them for you. Everybody heard the word nonconformity before? Ever hear the word grandfathered in? How about grandparented in? That's the proper term these days. Non-gender based. So grandparented in is the new phrase that we should be using. A use is grandparented in. Nonconformity is the general phrase. So again, I'm kind of a stickler on using the right words. Nonconformity is the broad term. A nonconformity is a use of property that was at one time legal, but is no longer legal because we've changed the rules. A house was built 5 feet from the side yard setback. We changed the setback, and at the time it was a 5-foot setback. We changed it to 10. That property is no longer conforming. Now, here's where the umbrella term diverges. There's non-conforming use, which is a use of property that is no longer allowed in that district. And there's non-conforming, or sometimes called substandard structure. So in my example, let's say that we had a business built on a property and we rezoned it residential. That would be what? Non-conforming use. A use no longer allowed on the property, a use that does not meet the use provisions of our ordinance. My example of the house, let's say it was residentially zoned property, still is 5 feet from the side yard setback. Now the ordinance requires 10. That's a non-conforming structure or substandard structure as well. Usually the distinction doesn't make a difference, but it can in how you use the terminology in your ordinance. So be very careful about that distinction. But nonconformity is just some of the highlights on nonconformities. Concept is, of course, we can't, in my example of the house built 5 feet from the property line, can we tell that guy, oh, sorry, we've changed the rules, you have to tear your house down? Of course, we can't do that. So this concept recognizes that they have a right to maintain what they had that was at one time legal, but no longer meets our requirements because we've changed the rules. Now, do they have a right to expand? What do you think? You're all somewhat right. The answer is we have control over expansion of nonconformities. So the state rules in 394 that deal with nonconformities allows them to be there, and due to some recent changes that we discuss in the materials, allows even if the nonconformity, well, let me state that another way, allows them to repair, replace, maintain, and improve. Used to be that the tricky cabin owners up north, before that concept existed, would always leave a few sticks of lumber up and say that they had a right there. This wasn't, I'm not changing anything at all. And they had to do that under the pre-existing law, but now under state law, for a nonconformity, a property owner has the right to repair, replace, maintain, and improve the nonconformity, usually a nonconforming or substandard structure. So that cabin that doesn't meet the lake setbacks now, I mean, they can literally, I think under that language, they can take it down to the ground, take out all the studs, and rebuild the thing in the same exact footprint. But the statute says, but not expand. So we locally have the ability to define the rules concerning expansion of a nonconformity. I heard one comment of, well, they can expand as long as they don't increase the nonconformity. So that's a common provision in an ordinance. But we have the authority to be able to decide if we want to do that. What is expansion? Is it two-dimensional? Or is it three-dimensional? Or can it be even something more than that? Let's say that someone has a cabin that has 2 bedrooms, and it's a non-conforming cabin, and someone comes in and wants to do some interior renovation that then turns it into a 4-bedroom cabin. Is that expansion? Footprints remains exactly the same, 3-dimensionally. What do you think? Is that expansion? I see most head shaking. Well, What about the fact that now you're going to have a whole lot more people that can stay there, and they're going to put a greater burden on the lake and have increased activity? Let me throw in the fact this is a natural environment lake, and this is right by the shoreline, and is that expansion? Yeah. My point is it's up to you to define. So however you define expansion and want to develop rules for expansion, that's the right that you have.
Question. I thought I heard you say that recent changes in statute changed such that a property owner has the right to repair, replace, maintain, improve, but not expand.
Yeah, that's number 6.
I'm sorry. That's from my notes.
Oh,
anyway,
yeah.
So this is a case in which the legislature allows the counties to do something less stringent than they put in statute?
No, this is a case where they have, a property owner has a right to repair, replace, restore, maintain, and improve. So we can't say anything. We can't say, sorry, you can't repair, replace, maintain, restore, and improve.
I thought the words
Nope.
actually said, but not expand.
Yeah, it does say, but not including expansion. So the statutory right that they're given does not include expansion. That's why it's our local decision whether we allow expansion or not. So the state has said they can do all those other things, but they can't expand. But we could locally decide under what circumstances we would allow expansion or not. That's the division of authority. Does that make sense?
I know.
What about the 50% destruction?
Yep, that's number 7. So that's another issue that arises. So now I've talked about what is a nonconformity, what are the breadth of their rights to be able to change or modify it. Under what circumstances might a grandparented in nonconformity lose those rights altogether? And what the statute says is one circumstance is discontinuance. Look at your ordinance and make sure you don't use the word abandon. I've seen that oftentimes in counties. Abandonment is a concept that requires intent. So for us to demonstrate a non-conforming right has been lost, if we use the word abandon, we have to demonstrate that they intended to leave it and never come back, which is a harder thing. Discontinuance is non-intent based. It's the fact, was it being operated or not whether the property owner had any intention of doing that or not, but just was it there or not. So discontinuance is the key. So that's one way it can be lost. If we can demonstrate that it's been discontinued for a year or more, any given stretch, not a calendar year, any given period of a year, then that right can be lost. Second way is if it's destroyed to the extent of 50% of, and I say market value in the outline, but put a little note there saying assessed market value. Because I think the statute was changed. There had always been an argument about, what does market value mean, and there are differences of opinions on that, and it referenced the county's market value. So if it's destroyed more than 50%, then it can be lost as well. But, again, the legislature always fills in these little holes over time. If it's homestead or non-homesteaded residential real estate or seasonal residential real estate, they don't lose it if they apply for a building permit to reconstruct within 180 days. So that's a little exception to that loss of the non-conforming right if it's destroyed 50+%.
The only caution I roll in this section is floodplain.
Oh, correct. Yep. Yep.
There's substantial
And I thought I put that in there, but maybe I put that somewhere else. That's a good point. I thought I had that in the outline somewhere. But yeah, floodplain is totally special rules.
With regard to non-conforming uses discontinued for 1 year, what constitutes continuous use of a non-conforming use?
We've discussed that over the time. That there's no bright line standard for that. I think when you're talking about continuity of a commercial use, you have to make a determination based on reference of what is some sort of industry standard for that. So if in the community the standard is that a particular industry is intermittent in nature, then the fact that that something in question is being operated intermittently, but in a manner that's consistent with other similar industries, then I think it would be difficult to demonstrate loss of a non-conforming right based on discontinuance. Does that make sense? So if in mining, if mines in a community are typically operated in a way that it might be a year and a half between projects where they come and take out a significant amount of sand for a bridge project or a road project, and that's the way you can demonstrate that, I think it would be difficult to say, oh, all non-conforming mines in this county are gone, because here we can point to 1 year where there hasn't been any activity on this mine. That's how I would look at it. Answer your question?
Have the courts ever had a look at that? In the state?
I don't know that a court has looked at that particular issue. Courts, when they have looked at non-conforming rights of mines, they have construed those rights more liberally because of the nature of mining. For example, when faced with a question of whether a non-conforming mine's right to mine was limited to a particular property, the courts have said no, they have a right to follow the vein of sand and applied special rules to mines. So that's all I can say about it. There aren't a lot of cases on mining and nonconformities, but I think it would be difficult, aside from mining, I think it would be difficult for any county to take the position that a non-conforming right's been lost under the 1-year discontinuance where the nature of that activity is such that that's par for the course. But that's what keeps us lawyers in business too, is that there hasn't been a case that addresses that particular issue.
Houston County case with the DNR with the sand mine on Highway 16.
That had nothing to do with this continuous use.
That was the trout stream setback requirement. That was a DNR issue, not a county issue.
What about Hawkins v. Talbot?
Pardon me?
What about Hawkins v. Talbot, 1959?
Oh yes, my favorite case.
Is it really?
No, I don't memorize cases,
Oh, okay, well,
so you'd have to tell me what that says, and then I'd have to study it.
where there was an expansion, supposedly, of a non-conforming, I believe it was sand or shale, and the neighbors next door said, they're expanding on a non-conforming. And the court ruled that the size of the mine was the extent of the parcel itself, not the open pit.
Yeah, that's the case I'm talking about. I didn't recall the name, but that's the case that I mentioned. Yeah, that was the argument, and the court said no, they had the right to follow the vein of sand beyond the limits. Yep. Yes. It is my favorite case. I didn't know it by name, but I do know of it.
Yeah, wait till you get my kill.
Yeah, that's right. Let's jump to. I've talked about interim use permits already. I want to talk a little bit about intergovernmental relations, because I think there was a question I asked someone to hold about township, county, zoning authority and how that all works. And hopefully as we discuss this, I'll answer that question, or at least we'll pull it off the table and try to answer it. Concurrent zoning authority. So there are cities and towns that have authority under Chapter 462, and then there's the county that has its own authority under Chapter 394. But cities and towns are located in counties. So how does that all work when someone owns property in a city or a township? What regulations apply, and how is that structured by state law? So in a county, for our purposes, we have the authority to adopt official controls and apply them in the county outside city limits. So unless the city has asked us to apply our ordinances in city limits, I've only seen that once before. So cities are easy. Our regulations don't apply in cities. The issue is, how do they apply in townships where townships are engaging in land use activities?
What if the county has setback requirements for feedlots and so forth, and the city moves closer to the feedlot, it's
Not a darn thing we can do about it. We don't control the use of land within city limits, so we don't have.
they come closer to our setbacks.
Yeah, we don't have the ability to be able to prevent that from happening because we don't have jurisdiction within the city limits. We can have dialogue with them and strongly encourage them to recognize and honor and perhaps adopt provisions that make things work together, but we don't have direct authority to be able to deal with that situation, which is a case I have right now in Houston County. A situation like that. Towns, how does it work with towns? If the town isn't involved in the business of land use regulations, it's easy. Our land use regulations apply. But what happens if a town has adopted zoning or land use regulations? First of all, can a town piecemeal things and decide to regulate just one thing? Or do they have to take the whole kit and caboodle? What do you think? Nope, they can piecemeal it. We saw that with feedlots. Towns adopt feedlot regulations and don't want to regulate anything else. But a town can adopt a land use regulation that just regulates one activity. So how does that work with the county ordinance provisions? What state law says is the county ordinances serve as a benchmark for the town's ordinances. So a town cannot, remember we had that less restrictive, more restrictive discussion from state down to county? The statutes say with respect to town land use ordinances that they can be no less stringent than the county's ordinances. So your ordinance serves as a benchmark for whatever it is that the township is regulating. If your ordinance says they can't do something, then arguably the township ordinance on its face can't say they can do that, or have differing standards, setback requirements and whatnot. Can they be more stringent? Probably so, but they can't be less stringent. Now here's one issue I don't know that there's an answer to. Counties take different positions throughout the state again, is does that mean that it's just a facial analysis? In other words, when a county or a town adopts the ordinance, does that just mean that you compare the ordinances and that determines what the town can do? Or does this can't be less restrictive mean that when someone wants to do that thing that's regulated by the town and the county, that they have to go through both processes? Because arguably, if the county would say no to a permit, is the town being less restrictive in application by saying yes? What do people think? Is that admonition that the town can't be less restrictive mean not just facially, but as the ordinance is applied? In other words, they have to go through both permits to make sure that the county says yes if the town says yes. Or if the town says yes, the county says no, does that mean that they can't do it? How do you do it in your counties? If the town has regulations, they get the town, go through the town. How about Winona? Do we know?
Yes, we have only one township lot that has no zoning. They're complicated, they've adopted their own comprehensive plan. They've changed the zoning districts so they don't resemble the shoreline, floodplain, septic, everything's gonna still be to the county. However, they are issuing conditional use permits for feedlots, issuing all zoning permits, things like that.
Without coming through the county process separately? It's probably the more common situation for counties to say, when a town has adopted a regulation that deals with a particular use, you're the ones that deal with it. You've assumed that authority. So property owner, you go to them and we're going to wash our hands of it. And I think, myself, I think that's the proper approach, but some counties do things differently. We'll make some value judgments here about what we cover. "60-day rule." Does anyone care about the 60-day rule? Do you want to hear a nugget about what it is?
Got one question. When you put a moratorium on something, there's something in the hopper, I assume you have to send them a 60, you have to notify the applicant that is denied, stopped, or something.
Yeah, as a matter of good practice, you should, but as a matter of law, the imposition of the moratorium freezes that, and in fact, the 60-day period starts over once the moratorium is lifted. And the wording is more convoluted in the 60-day rule than that, but that's the effect of the wording.
But it's good to send them a notice.
I think so. I mean, as a matter of common courtesy, they're spending time and investing energy in an application. It might be nice to send them a little note saying, you might as well put that on hold for a while because we put a moratorium on. I'm just going to touch on the 60-day rule then, since you raised it, very quickly. Does everybody know what the 60-day rule is? Okay. Was adopted 1992, I think, when the Board of Realtors their members were losing sales because counties weren't processing these applications where sales were contingent on land use approvals, and they were pissed off. So their lobbyists got this law stuck in, and it's led to all kinds of litigation that's good for lawyers, but nobody else. So we've had a lot of cases on the 60-day rule. Essentially, it's a rule that requires us to make decisions within 60 days of the submission of written requests relating to zoning, septic systems, SWCD review, watershed district expansion, and MUSA, which you're not concerned about. That, just to be aware, that phrase has been defined so broadly by the Supreme Court that pretty much everything that we do in the land use area we should presume is covered by the 60 days. And then it relates, the statute says, to request for permit, license, or other governmental approval. The courts have said what that means is a particular request related to a piece of property. So we've talked about variances, that would obviously be one. CUP, interim use, that would be one. If someone asks or submits an application for you to change the text of your zoning ordinance, is that one? Is that a request for a permit, license, or other governmental approval? Courts have said no, that's a case. So that isn't one. What about an appeal of administrative determination? Remember we talked about that as a BOA? Is that one? Courts have said no as well, because that's not a request for a permit or for a license or for an approval. They're submitting an appeal challenging a decision made. It doesn't fit any of those things. So 60 days, there are issues that as to what it applies to sometimes.
Can a 60-day rule be extended one time? Is that
You can extend one time for up to 60 days. I always suggest take the full 60 days because you don't want to extend it for 20 and say, crap, we needed 25.
who extends it?
No, there's cases we talk about on page 24. There are cases that say that it can be administratively extended. So the zoning administrator sending a notice, extending it, these cases say is sufficient. I like to recommend that in your ordinance you say that the zoning administrator can do that just to avoid any question.
And the applicant doesn't have to agree to it.
Correct, yeah, it's not an agreement. We have a unilateral right to extend up to 60 days. We take the full 60 days. we have to do it in writing, notify them, and we have to give them the reason. And there's a case that says the fact we need more time is a sufficient reason. So I always like to say, recommend that we need more time to study your application as our reason.
Let me do one for you. Is it email and writing?
In email, there's a case that says an email is a written communication now.
Especially if we get a reading.
Yeah.
What's the difference between like a 60-day rule will apply to a cup or not regular building permit? How come there isn't any?
Well, that's the reason I said at the outset, assume everything you do is subject to the 60-day rule, because we're citing cases for your edification in here. The building permit determination is from 2003. In 2000, okay, I don't even have the date of the case, but on page 23 and item E in the middle of the page, 500 LLC. Oh, there it is. That was 2013 up in C on the top. 500 LLC was a Supreme Court case that construed the definition of relating to zoning as something that has a connection, association, or logical relationship to the regulation of building development or the use of property. Wow, that's pretty broad, isn't it? Do you think that's everything you do?
Pretty much.
Yeah. So, well, the building permit case was from 2003 Court of Appeals. The 500 LLC case says you should really assume it applies to everything you do in the zoning office.
It just surprised me that D, that statute does not apply to building permits. On top of D.
Yeah, I probably should amend that, shouldn't I? Yeah, it can confuse you by citing the capital management case again. Thank you. This is a work in progress. And we've been I started this outline more than 20 years ago, and I just add to it every year and modify it as things come up. It started as about 15 pages, and we're at 37 now, adding the things, but yeah, that one we should probably reorder. But follow the 500 LLC case. We've talked about the extension already. Completeness is another issue. We have the ability to kick something off if it doesn't meet all our requirements and then keep that 60 days from ticking, but we have to give them notice within 15 business days. One, that their application's incomplete, and two, telling them what's missing. And then three, it has to be missing by reference to a pre-existing rule or policy. So somewhere we have to have something in writing that says, here are the 15 things we need with an application, and it has to be one of those things that are missing. We can't say when we're given an application, oh, it would be nice in this case to have this. And we don't have any policy that requires a submission of that. So we reject something as incomplete, and we say, oh, give us this instead. We run the risk of violating the 60-day rule because we don't have any pre-existing policy or rule or ordinance that says that's a requirement for a complete application. So that's a tricky thing to be aware of, and be sure and be aware of that. I'm not going to talk any more about the 60-day rule because I think we've pretty much covered all the issues that come up with it. What does it apply to? How is it extended? How does completeness work? Consequences are damaging. They get the permit, notwithstanding whether it would have been granted or not. Courts have said when it comes to a permit where we have the right to impose conditions, what I have seen is if we violated the 60-day rule, the courts will send it back to the county for the imposition of reasonable conditions. Again, the word reasonableness. The lawyers can fight about what's reasonable in that remand context, but at least the courts have recognized that we shouldn't lose our right to be able to impose conditions that might mitigate some harm, that if someone wants to do something terrible, they shouldn't be allowed to get it under the 60-day rule. We can impose reasonable conditions, hour limitations, et cetera, that apply to that particular use. And the landowner can't get something that is illegal. So if someone came in and applied for a permit for a nuclear power plant in your backyard under the county ordinance, and you said, "Boy, this is so ridiculous," and you throw it in the circular file, they can't come in and say, "Oh, you violated the 60-day rule. I get to build a nuclear power plant in your backyard." If it's not allowed by the regulatory scheme, it can't be obtained under the 60-day rule. That's cited in the middle of page 25. Item C was in the context of someone who applied for a wetland permit for a certain amount of fill that state law limited it to a smaller amount, and the court said, no, you can't. You can't fill in violation of state law just because they violated the 60-day rule. You're limited to what you could have been able to do. So that's the 60-day rule. I'm going to talk about the public hearing, and that might carry us close to the end here. So far I've talked about the concept of zoning, our statutory authority, our limitations, the common permits, variances, conditional use permits, some of those unique areas, moratoria, nonconformities, 60-day rule. With all that background, now I want to spend some time just talking about practical things about conducting your public hearings when you're processing land use permits. First thing that comes up, I jumped to page 26, is kind of leading up to the decision process and leading up to the public hearing. So occasionally there are questions about how does the open meeting law apply, and in particular, how does it apply when we do site visits? Because site visits are kind of the common area where that can be questions. And if a quorum or more of a board or commission is together at a site visit, that would be a meeting. So I don't know what your practices are, but it's important to post that as a meeting. Question kind of comes up then, do we all ride together? Do we ride separately? I don't know what the answer to that is. Someone posed the question, well, if we get a county van and we're all in the van, a quorum of us, does that mean that it's an open meeting in the van? And what happens if one of our difficult citizens says, I demand to be able to ride in the van with those people? How do we handle it? I guess you'll just have to figure that out yourself. But just be aware that as you conduct site visits, that if you do that in a more formal way, that those can be meetings. And we do have an obligation to preserve a reasonable record of our official meetings. So I don't know what your practices are, but it's good practice to have minutes and take notes of what was discussed and what was observed at site visits. In fact, that information can inform your decision when it's time to make a decision on a permit, because you may see things at the site that are important for purposes of your standards. So noting that as a meeting, keeping the accurate record of the proceedings is important and can be helpful to you as well. So now I'm going to take you in the van back to the county board chambers, and you're faced with making the decision. And I've already talked about all those standards, so I want to walk you through the hearing process, offer some practical pointers. I think Kay raised a question. She's gone now, but I said hold that question, so maybe she'll look at this, and asked a question about redundancy and how we can manage that. So I'm going to offer you in these next few minutes some practical tips, assuming that you have a difficult, contentious issue. You've got a lot of people in the audience, and how you can balance that, if you remember earlier on, the due process right of people and our right to maintain our sanity and order and decorum and be able to get home at a reasonable time. So what I talked about that concept again, due process, notice, opportunity to be heard, but what rights do we have as a municipal corporate entity within the confines of those rights as well? We have actually quite a few rights to be able to maintain order and decorum. And here are some that, from my experience, both as a commission member and attorney, I think work well. The main thing, as I mentioned earlier in response to Kay's comments, is at least in those contentious matters, you should have rules, written rules, and they should either be up on a screen and/or read and/or available at the public table when they walk in. That way everybody knows about it, because as you think about how these things unfold, and you've probably all been through them, many of the people that you'll see in the audience, this might be the first time you've ever seen them, and it might be the last time you see them too. They have no clue as to how the process works, unless you tell them how the process works. So think about it as you have had kids. Think about how your kids would act if you never gave them the rules. You never told them what they should or shouldn't do, or created that structure for them. They'd do whatever they wanted, not because of their fault, but because they just didn't know what was acceptable and what wasn't. So in the same way, you have to have rules that inform all these people. Here's how things will go in this chambers tonight. And most people will follow those rules then. There's a segment of the human population that will never follow them. And there's nothing you can do about that. So write them off and recognize it doesn't matter what I do, they're going to come up and they're going to be belligerent and mean-spirited and engage in personal attacks, and that's just what they do. But you do that for the benefit of everybody else, because you stand a good chance that they will follow the rules. So having written rules and going over them at the outset. And here are some of those rules for you to consider. And just simple comments. These, again, are kind of logical. One is you must address all your comments to the board or commission. Have you ever seen a person, when they're angry or emotional, they turn to the applicant and start talking to the applicant? Or they turn around and incite the crowd and people start clapping, if you've ever had the clapping audience, and things start to get out of control? If you allow them to divert their attention to others or to the crowd, that's when you lose control. So the whole purpose of a public hearing and a process is they must address you. As long as you continue to retain their attention, you minimize the likelihood that the crowd will get stirred up and emotions will get heightened because of that direction of attention to others. Time limits and time cards. There have been court cases that say we have a right to impose time limits on people. 3 minutes is common, and a court case says 3 minutes is enough. There actually was a court case within the last year. I've always been asked the question, can people donate their time? Have you ever seen that before, the donation of time? 20 people get up and say, I donate my 3 minutes to this person, so now he can talk for 60 minutes plus his 3. And I've been asked the question, well, what do we do about that? And my suggestion has always been, well, have a rule that says you can't donate your time. And actually I think it was a school, it was Stillwater, I don't know if you follow cases, they had some school closing issues where citizens freaked out about that, and there were some lawsuits that came out of that. They had so many people that wanted to attend, they had a 3-minute rule, and they had a no donation rule. That was challenged, and in the court case, Court of Appeals said that was legitimate. So we now have a case that says a no donation rule is okay. So we can limit time, we can limit donations, prevent donations as well. I've seen, in addition to that, I've seen processes where people either have to sign up or they have to sign a card and give that to the board chair to call. And I think that's not a bad process either, because if our goal is to create order in our process, having things like that create order. So I have seen, especially with the cards, as names are called, people just are buying into the system. I mean, you call their name and they get up and they come up, they do their 3 minutes and they go sit down. Then everybody waits anxiously, oh, who's going to be called next? And then you call them and that person gets up and they come up, and you're creating structure and order, which we as human creatures like, and they buy into it, of course, except for those 5% that are still freaking out at the side and gnashing their teeth, but we don't do anything about them. Eric, you had a question?
Can you limit total discussion time on a certain subject, let's say half hour, or specific time limit?
Yeah, I would caution against limiting total time, because you are going to deprive someone of potentially their due process rights, aren't you? So I think that would be a concern. I've not seen that, but that would be my thought.
We had a county planning commission meeting here where I knew we were going to have really a long format, and yet, is there any way possible that when you know before you start that you're going to be there till 2 o'clock in the morning, you don't have to take all of the applications and still get around the 60-day limit? Is there anything you can do about that?
I'm not sure if I understand the second part of your question about the 60-day rule and how that plays.
Well, that was the reason I was given why
you were on the 60th day, so you had to make a decision?
No, but limiting the agenda. See, we had 5 CUP permit applications, and it took, or 8, okay, anyway, it took over 3 hours to get through the first 2.
Uh-huh.
And, well,
could this be a reason to table the end of your agenda, essentially? As it's 12 o'clock, we're going to call the meeting.
Yeah, you always have control over your agenda. So, that can be, you always have the right. Well, at the outset, you may not know how long it's going to take, so you may approve the agenda with all those things. But certainly, once you've spent 4 hours on the first 2 and you're all spent and ready to go home, we always have the right to table things to a future meeting. We don't want to run afoul of the 60-day rule by doing that.
Can you invoke an extension?
Pardon me?
Can you table and then ask, go for an extension? Propose an extension?
Is our hypothetical that this is the 60th day, or, yeah. Yeah, certainly we could. I would like to think that you wouldn't get yourself into that situation. But I suppose in theory, if it's the last day, you don't think you have any energy left to get to those other 6 things, the 60 days is going to run out, then, probably, again, the question was who can extend. It doesn't have to be the board cases, say it can be the administrator, assuming like the applicant is there and we can effect an extension under the statute, we could do that. But I mean, that's a pretty, I wouldn't want to be in that situation regularly.
Well, certain months of the year, certain
Yeah.
months of the year, people are going to be wanting,
That's a reason to maybe just extend, knowing that can happen, extend it before you get into that situation. Kick it out another 60. Stephanie?
The big problem that we run into is where the planning commission meeting falls in relation to the county board meeting at which CUP could be approved. So that's
Okay.
why we're running into that 60-day
All right.
problem. That essentially cuts our time period down to 30 days.
Yeah.
Or slightly bit after. So that's why we're running into that issue.
Yeah, well then maybe either you change your process or you adopt a practice of extending everybody another 60 days automatically. And the reason is because our process doesn't allow us to get done.
So, do you have to table, can you recess and reconvene a day or 2 later? Well, I'm assuming it's the county board that the 60-day rule applies to, not the. So the county board meeting, if there's an overlap, you recess and reconvene before the county board meeting, so you can get that done and give it to the county board.
Well, it sounds like
You have to have more notifications.
it sounds like you're trying to fix a problem that might be fixed in another way. instead of getting tricky about all these nuances of recessing and meeting needs.
That brings another question. Do you have to notice an extension or a continuation?
Yes, you have to give the applicant notice, written notice of the extension.
So if it's through the public meeting?
No.
But at the meeting, if the applicant said, yeah, I'll extend it and agreeable right at the meeting, you just follow that up with a written.
Yeah, and if you have noticed that as the public hearing and it doesn't happen, either you have to continue the public hearing to a date certain, or if you don't, then you probably have to renotice the public hearing again.
Continue it at that meeting so everybody knows it.
Yeah.
Otherwise,
Then you don't have to pay for the cost of renoticing, but I'd be happy to talk with you offline about these logistical problems you apparently have, and we can figure out a system. Another going back to these practical pointers, and this is this I think is the question that Kay raised, and a general rule I always advocate: please avoid redundancy. You can't control this, but you can guide the people in a way that minimizes the likelihood that 50 people are getting up saying the same thing. So what I always suggest is that one of your rules is you encourage them to either, and this is another kind of sub-suggestion, either have a spokesperson speak for a group and express the common held belief of the group, or if you agree with a position someone previously took, just tell us, I agree with that person. And that's enough. Rather than say the same thing for 3 minutes over and over and over again. So I think in our rules we can encourage that, avoid redundancy, elect a spokesperson for common held beliefs. I mentioned the don't read letters at the outset. This used to drive me batty as a planning commission member, that I'd have a packet of 50 letters and I'd be so darn diligent and read them all before the meeting. And then I'd attend the meeting and lo and behold, I'd have 50 people come up and read the letters to me from the beginning to the end. And it just seemed like such a waste of time and was frustrating. So encouraging people, and I think you have to couple it with, we've received your letters have been distributed, your letters have been reviewed, it's unnecessary for you to read the letter, but please state that you have submitted the letter so that we have a record of that. Most people will do that instead of read it. But that can be frustrating. Another rule that I advocate is no personal attacks. This seems kind of like commonsensical, but to say that there will be no personal attacks and they won't be tolerated and they'll be ruled out of order if the chair determines that people are engaging in personal attacks. And then the last one that I typically throw out for consideration is just reminding citizens that when they're offering you information, that they shouldn't just tell you that they're opposed to something, because does that mean anything to you? I'm opposed to it. Let's say everybody in the room says I'm opposed to it. It's meaningless, isn't it? The courts say public opposition is not a basis to deny a permit. So the fact the whole world or the whole county is opposed to something means nothing. It's the reason that they're opposed that's important, and those are the facts that will touch and concern your standards. So I always suggest as well that, again, assuming people aren't familiar with the process, that they have to be told, please don't just tell us that you're opposed to something. It's important for us to know why you are opposed to it. Are you opposed to it because you think it will devalue your property? And if that's the case, tell us why you think that, what you're relying on for that conclusion as well. So that, that's really the reason of the whole hearing process, is to develop facts for your consideration to apply to the standards. And you get nothing if all they say is I'm opposed to this, because you just don't know why, and it's not meaningful. And finally, the last thing in conducting the hearing, I'll share with you the line that I used to use as a planning commission chair and worked really well for me. And if you feel you're in a position to try it, go ahead and try it. And if it's successful, let me know. I'd like to hear follow up about it. But it goes something like this: when someone is taking too much time or getting out of hand, and there's a large crowd that, for example, oppose a particular use, I would say to that person, you know, we have a limited time tonight to be able to hear from all the people in the audience, your neighbors and your friends who have similar beliefs to you. You're taking their time, and I want to hear from them, not just you, but I want to hear from your friends and your neighbors, what they feel about it, how they feel. And you're disrupting this process, and you're depriving them of the opportunity to tell us how they feel. That's not right. Oh, shit. So to turn them, to make them feel like they're screwing their friends and neighbors is better than make them think that they're screwing me and taking my time, which they don't care about. So that's a line you can try, and you can tell me if you think it works. All right, I'm going to zip through now. I'm going to talk about the record and facts and findings and just wrap it up.
When we had one issue for a CUP, it was regarding puppy farm, you know. We got comments, emails to the planning coordinator from all over the United States. Now, do they all have to be public record, or, you know, sometimes I think I'm getting an encyclopedia when I get my planning meeting agenda back.
What a great segue into my next topic, the record. So, do they have to be part of the record? What is the record? And then I'll answer your question. This whole process of processing land use requests is designed to generate data so that you have data available to make decisions to apply to the standards in the ordinance. If there's a challenge to the court will look at what's called the record, the data that was produced in your process, to determine if there are facts to support the conclusions that you had about the standards. So think of a zoning decision as like a big machine. And our whole job, starting with the application and the processing by staff and your public hearing, is to feed information into that machine. And that information is important because when a court, as I mentioned, when a court reviews a decision, most decisions are reviewed based on the record. So we have the great opportunity to control our process. I, as the attorney for the county, have an obligation to assemble the record and send it into the court. So I'm the one that says, here's the information that we generated in the process and that the board or commission considered. So it's always to our benefit to have as much information as we can. So the record is, and when I'm talking about the record, I mean the application, the minutes, the findings, all the letters and emails you got in support and opposition to the project, the internal memoranda from other departments of the county, maybe the engineer, that talks about the concerns he or she has about impact on roads. If it's a shoreland issue, maybe the local DNR hydrologist that weighs in on it, internal and external comments as well. The audio tape, do we both audio tape? Audio tape, yeah, the verbatim transcript that we can make from an audio tape assists us because it makes the record clear and complete. So all that information is what's the record. And when a court has looks at two things when a decision is challenged. Was the decision made, oh, I shouldn't do that. One, was the decision made for at least one legally sufficient reason? And two, are there facts in the record to support that reason? So our process of generating this stack of paper, I know it's an encyclopedia, but it's only to our benefit. Our effort at creating that big stack of paper serves us well in the end. And it's important because the court needs to believe that we did a good study. Case in point, I'm not talking about the merits of the challenge to the Winona ordinance on mining, but we submitted 2,700 pages of materials from the county's study of that process to the district court, saying, here's the record. Here's what the county looked at when they were making this decision. So in that sense, hopefully you can see why the record is what it is and why the record is important in making a decision.
You, on number 2, it said all the documents. Does this also include testimony?
Yeah, because testimony is, again, we tape, and when a decision's challenged, we have a transcript made. So everything that happened at the proceeding is part of the record. The minutes, the findings, and everything else I mentioned. Pretty much all the documents that maybe weren't even part of this process, but we referred to, let's say, oh, maybe a board member says, oh, you remember 5 years ago we got that study that talked about this thing, and I think that's important here, and then there's some discussion. That thing's pulled into the record, that study. Photographs that are taken of the site are part of the record. So again, because we as the attorneys for the county get to send up the record, we have a lot of control over compiling that and assuring that the court gets what it gets. So I'm going to take us, because of lack of time, I'm going to take us through to making a decision. So again, I asked you to picture the machine. So where our whole process is designed to generate data, and we're feeding it into the machine in your mind's eye, and picture in that machine that all the standards for the various, for the permit at issue exist. So if it's a variance, all those things we talked about. If it's a CUP, all the standards in your ordinance. So now you as decision makers have a job to do. And what's that job to do? Applying facts to the standards, right? You're asking each of those questions that I walked you through on the particular permit or whatever the permit is. You're saying, okay, now it's time for us to make a decision. So we've amassed all this information through this process, so let's ask ourselves these questions. Is this variance request consistent with a comprehensive plan or not? Is this variance request reasonable? Now I'm going to take you back to the examples that I had, and we're going to talk about findings. So if you say, as part of your process of making a decision, we want to have findings. If your findings say, let's use my variance example. If your finding says, request is not consistent with comp plan, period, is that going to hold up in court? Why not? What's missing? What's missing? The facts. The facts are missing. That's just a restatement of the standard, isn't it? You're missing the process of applying facts to standards and making a reasoned judgment, substandard by substandard. So if we just recite the standards of that particular permit, we lose. There's a case that says we lose. The whole process requires application of fact to standards and a determination made. So going back to the comp plan, remember my example was the hill, house close to it, concerns about traffic. Determination by Board of Adjustment. This request is not consistent with the comp plan because the comp plan says this. We heard testimony that indicated that cars travel at a high speed crossing over the top of that hill, and we believe, based on whatever, that will present safety concerns not just for the occupants of that and future occupants of that home, but also for the traveling public. That whole statement you see is application of fact generated in the process. You heard from people that said that. You looked at the comp plan. And then telling the court what you thought, what you concluded, and why. So every finding should always be not just a regurgitation of the standard for that permit, but application of law to fact in the form of why and because, or why not and because. So we believe this standard has been met or has not been met. because, and then we discuss the facts that the process has generated. And really, so that's the importance of the record, is it's our source of fact. And that's the importance of findings, which is application of law to fact. And I'll say to you, if you go through this process and you give me solid reasoned findings that are based on facts that aren't made up, but they're in this stack of papers that I will have access to, in most all cases we'll win. We'll lose some now and again because judges are human too, but in most cases we'll win because judges don't want to overturn decisions from my experience. By law, they're required to give us deference and not substitute their judgment. They're only looking for, is there a legally sufficient reason? Are there facts in the record that support that decision? Even had I disagreed, even had I been on that board and I would have gone the different direction, a judge is not supposed to mess with our decision.
So do you want to find a factor, a 5 vote on the Board of Adjustments? You want 3 yeses and 2 no's? You want finding of facts? You want 5 votes? You want one general finding of facts on which was the majority?
Yeah, there has to. This goes to precision in the decision-making process. And, I've always been asked, how do we do that? What if everybody doesn't agree with all the findings and whatnot? Unfortunately, it's incumbent on you to come to a majority decision and adopt by a majority vote a set of findings that support that decision. So that can, involve back and forth. Well, I don't agree with that finding. Oh, well, I'm not going to vote yes then because I don't agree with that. Well, how can we craft this and that back and forth? But ultimately, we need to end up with a product that says yes or no to the permit and the reasons that that body, that majority voted for that. Because those constitute the reasons of the body that denied or granted the permit. Does that make sense?
Yes.
Okay, in our staff reports, we'll provide proposed findings.
Yep.
And there'll often be a motion to accept the findings as proposed, but we won't actually vocalize every one in the hearing. Is that acceptable?
It's, as a matter of practice, that kind of goes to the rubber stamp argument that I've seen. Let's say that, let's carry your example to the extreme. You have a variance application. Staff has a bang-up staff report with detailed findings of fact. And the Board of Adjustment opens a public hearing and then goes to discussion and doesn't say a thing. There's no discussion at the board level. All the board says is, move to approve the finding second, all in favor, aye, it's done. Now, that's not a fatal thing, but what does that look like? If you're a judge, what are you going to be thinking? Well, did they really give this a reasoned evaluation or not? So
That doesn't really resemble our process. It's just the time-consuming of going through all the findings one by one, but there's always a discussion of the proposal generally. It's not necessarily a discussion of each required finding. Oftentimes there'll be one that we specifically pick out to discuss.
Yeah.
But others that we don't discuss except as proposed.
Yeah, I think it's important to encourage the board to have some discussion to guide them through a process so that you end up with a record where the court can say, 1, they understood what the standards were. 2, staff made a recommendation. 3, they were cognizant of the standards and staff's recommendation. 4, they made a reasoned judgment. So that there doesn't seem to be anything nefarious there or a rubber stamp where a court's going to say, they were thinking about going home and watching Monday Night Football. They didn't really even think about this thing. 8 o'clock. I will miss it because I'll be driving. I'm going to wrap up with answering a question that someone had earlier about our role. Now another little nuance in the decision-making process that I just want to highlight because I've seen questions commonly on this is, oh my gosh, what do we do when we have people saying all kinds of different things? This guy got up and said this wouldn't have any effect on property values. This guy got up and said it would destroy property values. Who do we believe? What's one to do about that? And I just want to emphasize that typically these are quasi-judicial decisions that you're making. And by nature, what that means, by definition, what that means is you're acting like a judge or like a jury. You are presented with facts, and you have the ability and the right to be able to assess the credibility of testimony and what we lawyers call the probative value or lack of value of facts. So you're going to hear all kinds of competing things. Like in a criminal trial, they probably commonly hear, no, I saw Joe pull the trigger. I saw Bob pull the trigger. What are they to do? They have to decide who they're going to believe. Or they hear different things that are said. You have to decide who has more credibility in saying that. And on page 33, just to drive home that point, I cite a series of cases where courts have actually upheld decisions by land use authorities where they have chosen to believe citizens over experts. One case involving Super America, where they wanted to build a gas station on a corner in Little Canada. They hired some transportation engineer who submitted a big fat report concluding at the end, this is going to be great. The citizens who lived there came in during the public hearing process and said, we don't give a crap what that guy says. We've lived here for 25 years. I sit at that intersection for 10 minutes every morning trying to get out to get my job on time. How can you tell me by putting more traffic at that corner that it's going to get better for me? And citizen after citizen says that. The city said permit denied. Court said the city had the right to give more credibility to those people who had firsthand knowledge, even over an expert. And there are a couple other cases I cite where expert testimony was rejected. So it just stands for the proposition we have great authority to be able to assess credibility of people and what they say. I think it's good practice that when you have competing evidence, and you can do it oftentimes in the findings, to recognize that and then inform the court why it is you want a different direction. So, for example, on a conditional use permit, oftentimes it's the property value standard you have in your ordinance. Let's say you heard all kinds of competing things. You could say the board concludes that this proposed use will not have a negative impact on property values. The board heard testimony from X and testimony from Y. The board determines that the testimony from Y was more credible because the Y is a licensed real estate appraiser and X is just a local realtor who's not trained in actually assessing market values and impacts of projects like this, blah, blah. Just an example of when you have that competing evidence, how you have the right to be able to assess the credibility of it, but then let the court know that you saw that and why you made a reasoned judgment one direction or another. And with that, I'm going to leave the rest to you. I think we've covered most of the topics. If you have any other questions, let me know. For the gentleman in the back row, did I ever answer your question? Did I ever answer your question? I can't remember what it was. I think he was taking a little nappy poo. So the answer is I don't care. I'm done. Well, thanks for your time. I hope it's been of value.